Good morning and welcome to the District of Columbia Court of Appeals. Thank you for your patience. We were delayed a few minutes this morning. I'm joined this morning by Judge McLeese to my right and Judge Howard to my left. We have three cases. Our first case is Animal Outlook versus American Heart Association. Counsel for Animal Outlook, Ms. Huggins, is appearing remotely. Counsel for American Heart Association, Mr. Hirschfeld. Okay. Good morning. Ms. Huggins, are you ready to proceed?
I am, Your Honor. Would you like me to make argument or will you have questions?
Did you wish to reserve any of your time for rebuttal?
Yes, Your Honor. I would like to reserve time.
Right. Thank you. You can proceed then.
Okay. So the appeal basically falls into four separate categories. The first is that the trial court erred in considering matters outside the complaint, and the parties do not dispute that the trial court considered matters outside the complaint. In the order itself, the court says that it was accepting facts that were proffered by American Heart Association. And this is in violation of Rule 12D of the Superior Court, which says if on a motion under Rule 12b6 matters outside the pleadings are presented, the motion must be treated as one for summary judgment. Under Rule 56, all parties must be given a reasonable opportunity to present all material that is pertinent to the motion. And this is not permissive language, this is mandatory language. And we were not, Animal Outlook was not given that opportunity here. Rule 56F of the Superior Court rules reiterates that rule and says that the trial court may grant summary judgment sua sponte, but only after giving notice and a reasonable time to respond. We were not given that opportunity here. We objected to the presentation of factual matters in our opposition to the motion to dismiss. Trial court did not address that either, just simply considered the outside information. American Heart Association does not dispute that outside matters were considered and doesn't cite any law to the contrary of what I've just said. The Washkowiak case that they relied on, in that case, the trial court said it could affirm if considering only the complaint, no cause of action was stated. But in that case, the court said it couldn't do that and reversed the trial court for considering matters outside of the complaint.
Well, Ms. Huggins, our case law does allow for to some extent a broad reading of matters outside the complaint. And here, as I understand the American Heart Association's argument, there was an attachment to the complaint that included some information that they argue allowed for the court to reach certain conclusions that you say are outside of the record. What do you have to say about that particular attachment? I'm not recalling the name of it, but it was one of the brochures that showed the sort of the flow of the process used to certify whether something is heart healthy.
Well, the certification flow chart that was attached to the opposition to AHA's opposition, is my understanding, and
But
not
your argument is that that doesn't contain information from which the trial court could have reached some of its conclusions.
Correct. I mean,
relatedly, I mean, I think a variant of the Chief Judge's question is that there is a principle that documents that are not attached to the complaint, but that are referred to in the complaint can sometimes be treated as though they are part of the complaint for purposes of motion to dismiss. And I do think that that certification, the Heart Check Food Certification Program guide, a particular page of it, but was cited in your complaint. I'm focused on page 11 of the complaint, footnote 20. And so do you, at least that Heart Check Food Certification Program guide, because it was referred to in the complaint, was fair game for the trial court in ruling on the motion to dismiss?
Well, it's not, I mean, a couple points on that. First, it's not clear from the order exactly what the court was referring to. It just says to facts proffered. So some of these facts, for example, the trial court says AHA does not benefit, one of the facts they relied on,
I
AHA
understand that
does not.
I will
Right.
understand it doesn't necessarily answer all of the questions about what the trial
Right.
court relied upon. I'm just curious about this particular document and whether you agree that by citing that document in your complaint, you made it fair game for the trial court to take into account in ruling on the motion to dismiss. Whatever, I understand there's a question about what all it might include and how it might relate to what the trial court ultimately did, but.
Right. I mean, it's a difficult question because the Heart Check certification program has lots of different components to it. So I think we would need an opportunity on a Rule 56 to confront the information that's presented, because what exactly consists of that guide is somewhat in dispute. And I don't, if that makes sense. It's a
I mean,
constantly evolving. It's there's a lot of documents. If you look at the AHA website, there's a lot of documents that are part of the Heart Check certification program. So it's
understood, and you cited a lot of them, a variety of them, not just the guide
right,
itself, but various kind of FAQ kind of documents as well. And I know you cited it
right.
for a year, but just generally, I mean, I understand by it, I'm really asking a legal question. I understand that there might be practical issues that relate to it, but the legal question is, do you think it's legally true or false that by citing a document in a complaint, a plaintiff makes that document in its entirety part of the complaint for purposes of ruling on a motion to dismiss? Do you think that's a correct legal, is that a legal principle, or do you think it's not?
Yes, I think that is a legal principle. I think it's somewhat in dispute what exactly that consists of in this case, given the amorphousness of the program.
Was there any part of that document that did talk about the heart certification program as being cost neutral, for example? That seems to be a contention that you dispute or contend that was outside the record.
Correct. I mean, we hotly dispute whether the program is cost neutral. It's a fee program. AHA admits it's a fee. They categorize the fees as administrative. We're unclear exactly what that means or what they're categorizing as administrative. Again, that's a factual dispute here. But I mean, for a defendant to simply say, "Oh, I'm not benefiting," that would, diminish many lawsuits if that was sufficient to survive a motion to dismiss.
So I take your point to be that along the lines of what we've said recently in our Tovar case, that when things are referenced, as Judge McLeese noted, and the chief has in her question, they're kind of fair game. And we said in Zajac that if documentary evidence that's appropriately considered flatly contradicts a well-pled factual allegation, then that allegation does not have the same standing. But just to be absolutely clear, your point is that these are contested facts nonetheless. Like, it's a complicated set program with a number of documents that do not appear entirely aligned and readily interpretable, and that this is something you need a discovery on.
That's exactly right, Your Honor. That's exactly our position. Whether they benefit from the sales, whether once the administration fee is paid, AHA does not obtain further payments. These are all things we dispute. AHA certification of a product is not conditioned upon or connected to whether the product is ever sold to consumer. These were the facts that the trial court said they were relying on, and we dispute these facts.
Can I ask you, you also sought to amend the complaint.
Correct.
At what juncture exactly? You filed?
In opposite, oh, sorry.
No, you filed the request to amend the complaint and the trial court denied that motion. And that's part of the basis of your appeal here as well.
Not exactly, Your Honor. So we had filed the complaint and then it went up to the federal court on removal and all that. When we came back down, we decided to get rid of the common law claims. We had 2 common law claims. And on consent motion, we went in, everyone agreed, the trial court will let us amend. That's how we wound up with the first amended complaint. And then in opposition to the motion to dismiss, we made the request for leave to amend.
The trial court did not seem to consider the second prong of the merchant statute definition, which looked at trade practices. Did you, I guess, did you tee that issue up for the trial court at the time?
We believe we did. And I think, one of the issues here is the trial court relied very much on the fact of the good, the beef, and we're arguing separate and apart from that. American Heart Association markets a service to the consumer, which is this nutritional testing program. It's marketed directly to the consumer, so we dispute that it's not a quote consumer-facing transaction, then simultaneously turns around and markets that directly to the beef manufacturer and puts their label on the product. So it's it would be somewhat of a loophole within the CPPA to allow a third party to have that direct a role in a consumer-facing transaction and not have liability under the statute.
Ask you how far you take, can I ask you how far you take that theory? So, do you think that if I'm a media company and I, for pay, run ads, so, companies pay me and I run their ads and their ads make representation to consumers. Do you think that I am liable under the CPPA under a trade services theory if the representations that are made by the whoever I'm letting advertise are false or misleading?
Possibly. It depends. If you then put your label on a product, if you on the one hand,
I understand.
Right.
I understand that my hypothetical is a harder case than what your view of this case is, for sure. I get that, but I'm
Right.
just curious how far you run in other circumstances, and you could say that if I am an advertiser and I'm marketing my ads to the consumer in the sense that I get paid by people for doing it and it's a commercial enterprise on my part, and there's false information, I can see under a broad interpretation of the text of the trade services theory that there might be liability under the CPPA for only doing that, not for doing more, like I know you allege AHA does, but for only doing that. Shoot that broadly, or whether you don't. And it sounds like, at least so far, I'm not quite sure whether you do read that broadly or whether you think there more is required, and if so, what you think that is.
Right. So under Praxis and Dahlgren, which are two cases, I believe, addressed by both parties in their briefing, I don't think general statements made to the public in Praxis, it was general statements made about soda. In Dahlgren, kind of general statements made about cell phones directly to the consuming public. Those were not enough under the CPPA. So if that's what you're asking, no, I don't think those kind of general statements about a product are enough.
I mean, those cases are not binding on us, and so you don't have to argue they're correct. You don't have to them as correctly decided, but it sounds like you are taking them as correctly decided and distinguishing them as involving conduct that was less consumer facing than the conduct at issue here. Is that a correct understanding?
Correct, Your Honor. Correct, Your Honor. And if I could just address the Chief's question as well. You asked if we had teed up the trade practice issue. It's on page 362 and 363 of the record, which is in our opposition. We said AHA also qualifies as a merchant under the second prong of the statute, and go into that discussion, and none of that was addressed by the trial court.
All right. If there are no further questions at this time, we'll reserve your remaining time for rebuttal. Thank you.
Thank you, Your Honor.
All right, Mr. Hirschfeld.
Please the court, Leslie D. Hirschfield, Marks, O'Neill, O'Brien, Doherty, and Kelly on behalf of Appellee American Heart Association. Let me first address a question that the Chief Judge addressed with regard to the leave to amend. In particular, the application of leave to amend for Rule 7 and Rule 15. The leave to amend in this case was requested the first time in the opposition. Even in that opposition, it violated both Rule 7 and Rule 15. The leave to amend doesn't advise the court what allegations Animal Outlook could make to cure the deficiencies. Did not state the grounds for seeking amendment. It simply said, and I quote, should the court find any deficiencies? No specific grounds. They couldn't, because there aren't any specific grounds that would bring American Heart Association into the CPPA. On appeal, they list two, which are rather nonsensical. Testing increased the sales of the product, and I don't know how you would ever prove that. And somehow donations to the American Heart Association increased when consumers see the heart check symbol. Again, wild statements, unprovable.
Remember, the first one is that you use the word testing, but I think they would probably argue testing and certification.
Certification, but the word they used was
You're saying
testing.
it's just make sure I understand. You were saying it's a wild theory that your certification is beneficial to companies in selling their product. You think that's
Right, so you'd
wild
have
assertion?
to show that a specific brand of meat.
Well, then what's the point of the certification if it doesn't,
It's
I don't think it's such a wild theory.
educational, and it'd be very
So,
difficult for a
so consumers go into the grocery store and see the heart check sign and they trust the American Heart Association as one of the oldest nonprofits, and they only think educationally, I'm going to look at this. They're not drawn to purchase it.
It may be. However, there's so many other factors into purchasing the meat, whether it's going to be more or less, whether this product costs more or less than another product. Maybe it's marked down. The point is, it would be impossible to prove. I think the point of Animal Outlook is,
Maybe not impossible, but maybe plausible. And that's what we're talking about at this motion to dismiss.
right, but even if it's, I don't think it's plausible. But even if I agreed with the chief judge, it has not been appropriately pled under Rule 7 and Rule 15, because you should not be considering issues that are raised first on appeal. This was raised first in the opposition on appeal, not below.
You say this, what?
The request for leave to amend.
Oh, understood. I think some of the questioning has now moved off instead to sort of the merits
Okay.
of whether there's a plausible claim in the complaint as it's currently written that AHA is a merchant.
Right.
And so leave aside leave to amend for a minute and just take the complaint as it's currently written.
Right. Well,
and focus for a minute on the trade secret line of thinking.
okay.
Why is it that the current complaint doesn't plausibly allege that AHA is a merchant under the trade secret line of thinking?
First of all, if you look at 283901 A3A, the definition of a merchant is somebody who would sell, lease, or transfer, either directly or indirectly, consumer goods or services. Now,
That's the first theory.
understood.
And I'm asking, my question is about the second theory. So if we move to the later in the statute, in that provision where it is also or someone who in the ordinary course of business, I assume you wouldn't dispute that the certification program is part of the AHA's ordinary course of business. That hasn't been the problem.
Correct.
Supplies, goods or services. So here, I think the theory is services, which would be the subject matter of a trade practice. Well, then you got to go figure out what a trade practice means.
Well, I think trade practice is modified, or at least given some explanation, under A5, which is what a respondent would be. Which is a respondent means one or more merchants alleged by a complainant to have taken part or carried out a trade practice.
Respondent, that's an interesting theory, which I'm not sure has been briefed, but let me just, for current purposes, respondent is not part of the definition of merchant.
Understood, Your Honor.
So let's leave aside respondent for a minute. We can add that complication in due course if you'll bear with me. But just on the focus of whether they're a merchant or not, then let's just figure out so a trade practice is defined in subsection 6 as any act, I'm going to leave out some words and feel free to raise concerns if you think I'm leaving out things that are germane to the answer.
If
but-
you don't read it, I will certainly correctly. I'll certainly correct you.
I'm sorry? You
I'll certainly correct you
read
if you
the whole
don't read it
thing?
correctly.
want me to read the whole thing? Well, I'm going to skip out some parts
No.
and you can add in whatever you like. So it says any act which does or would provide information about a sale of consumer goods or services. And so why isn't the certification program an act which does or would provide information about a sale of consumer goods or services?
I think
It's like, this is healthy food.
so. I
So-
think I think you have to go back to Howard versus Riggs National Bank, and you have to look at the legislative history which they outlined in Howard versus Riggs National Bank, and also, and I know it's a lower court, the Dahlgren case that was decided in 2011. When you look at those cases, American Heart Association is far removed from the supply chain. Further, they use the word further up the supply chain. And the fact, Your Honor, that the heart check mark.
To interrupt a little bit, I take from where you've shifted that you don't have a particular point to make about why that conduct doesn't fit into the wording of the statute.
I don't think it's a trade practice. I think it's a certification mark.
Understood, but which of the words do you think it runs afoul of the definition of trade practice? Is it you think it doesn't provide information about a sale of consumer goods?
I think it provides information regarding the healthiness of a consumer good.
It is being offered for sale.
It's being offered for sale, but not being offered for sale by the American Heart Association, which I think is important.
Wouldn't
American
that
Heart
leave a
Association-
tremendous gap in the statute? What I think of naturally are supplement sales, which are largely unregulated, and we rely on a lot of third-party certification and testing, NSF, SFE, et cetera. And a lot of people look at that calcium supplement or something and they say, oh, this has a third-party certification on it, so I can trust that this is calcium. I get that it may not be as intense of an example here, but how is that meaningfully different and why shouldn't that be regulated? Like, it really impacts.
What the American Heart Association, and we're not running from the check certification program. In fact, we embrace it and we attached it as a supplemental authority to our brief. What the heart check program does is it certifies that a product meets government standards. That's all it does. It doesn't somehow then transform the American Heart Association into somebody who's selling it, who's leasing it.
Can I ask you a
Who's
question
any
about,
of that?
let me ask you a hypothetical about the position you're taking. So imagine I start up a magazine that purports to recommend consumer goods. And the whole thing is a fraudulent scheme, really. And I accept payment from people who are marketing defective goods, and I know that they're marketing defective goods. And they pay me, and I put out my magazine, which purports to rate them and says, these are great products, you should buy them. Are you saying that's not covered by the CPPA because I'm not selling anything?
I think you have to look at Dahlgren for that.
Well,
And-
we don't really I mean, I'm happy to look at Dahlgren, I have, but it's not binding on us, so but.
And in Dahlgren, I realize it's the lower court, but I think the analysis is correct. Because in Dahlgren, you had the Telecommunications Association doing testing, trying to modify the way the public worked, actually impacting the public.
Does
and
that
even-
mean you think Dahlgren supports a conclusion that the answer to my question is yes, that is not covered by the CPPA?
I do.
That I can under a statute that's supposed to be broadly construed to protect consumers, I can start a business
Well-
where I knowingly falsely make statements to consumers
Well,
about the sale of goods. That seems like a tough conclusion to reach.
You certainly have all the fraud allegations and all the fraud all the fraud claims you would certainly have there. But in that case, and you also have to go back to the wording of Howard versus Riggs National Bank. I think the court there in 1981 said it's a broad statute, but it has its limits, Your Honor. I'd also ask that you focus on the actually what the really goal of Animal Outlook here, and that's paragraph 3 of the complaint.
Can I ask you a quick question about Dahlgren, which your briefs rely heavily on? Do you understand Dahlgren to be specifically analyzing the trade practices prong of the definition of merchant, or the first part of
The
merchant?
trade practices of the CITA.
Because it seems that this notion of supply chain probably maps on better to part A of the merchant definition than it does.
But you look at what Dahlgren, what the CITA was doing,
Mhm.
and they're not selling, they're not leasing. They're actually trying to, they're under the second prong, they're trying to influence the public. And I think the argument, and I understand Dahlgren's a Superior Court case, but
No, but and it's a case again that we've read as well, but this notion of supply chain doesn't map on, in my view, to the trade practices prong of the, I mean, I know that's how it was written, how it was analyzed, but you know, I don't see how you analogize a supply chain to a trade practice.
well, they can be different, Your Honor. And certainly here with the American Heart Association Heart Check, it is just, I want to focus on what it actually is. It's a check that goes on the label. That's it. It's a statement by the American Heart Association of a certification that it meets certain guidelines. That's it. Under no circumstances, though, under either the trade practice or the first prong, and I think we can all agree that American Heart Association, and it's never been alleged, sells, leases, or does anything else with regard to beef, right?
The argument is that, and one obviously can debate the pros and cons of it, but I think their argument is that you do indirectly sell it. You are
Right. So let me focus on the word indirectly, which is exactly what Howard versus Riggs, Dahlgren, Jefferson talks about. What this court should decide and needs to decide is what it means to be further up the supply chain. And when Judge McLeese says indirectly, I think that is definitive proof that American Heart Association is too far up the supply chain. In fact, we wrote it's two steps beyond the supply chain.
I'm not sure I follow your reasoning. It sounded like you were saying that anytime the person is not a direct seller, and the theory is that they're indirectly selling, they must necessarily be too far up.
No,
that can't quite be right.
That's not what Howard holds.
Well, no, I'm just asking what you're saying.
Right, but I'm saying when you look at Howard, you look at Dahlgren, you look at Jefferson, you look at the three cases, and I realize Jefferson's a federal court decision. The heart stamp mark is way too far removed from the actual seller. We're asking, Your Honor, that the court not permit the CPPA to be twisted or modified under what has been 45 years of law since Howard versus Riggs National.
Your opponent distinguishes Howard in part on the theory that the court relied in Howard on the idea that the alleged merchant there was sort of uncompensated. It was a disinterested entity. You think that's irrelevant to our consideration?
I do, and I think the whole, and my note here says that the whole how much you get paid. I mean, we embrace it. As I said, you can see on the first or second, actually it's page 8 of our supplemental authority. If you sell this much, it costs this much for a certification mark. If you sell this much, it costs this much. I think that's an entirely red herring. All of that.
Yeah, can I ask you, when you are making arguments that rest on the idea that AHA is far removed from the supply side of the transaction, I have the following reaction. I'm just interested in your response to it, which is intentionally AHA's heart check symbol is right in front of the consumer at the time the consumer is making decisions about whether to buy or not. That seems like at the point of the transaction rather than far removed from it.
It's all a matter of degree, and I think you have to go back to Howard. Miss Kelly, no relation to Mr. Kelly of my firm, at Riggs National made a recommendation to the consumer to hire a contractor. The contractor defaulted, didn't do the work. Okay, so you have to look at where this is up the supply chain. And in Howard, the bank teller, Miss Kelly, who recommended the work to Riggs, was found not to be liable, and Riggs National Bank was found not to be liable under the CPPA.
And Howard seems to me plainly correctly decided, among other things. It seems like that recommending activity was not in the ordinary course of business of that person. So I think one could take Howard as certainly correct, but not necessarily.
And even closer, I'm sorry, Your Honor, I didn't
No,
interrupt you.
that's fine.
Even closer, I think, is the CITA, which is, they made findings. I mean, look at the findings they made. The CITA tries to influence the public. The CITA markets to the public. The CIA tested cell phones. The CIA prepared, directed, and conducted and reviewed and funded scientific testing of cell phones. The CITA marketed. The CITA attempted to influence consumer purchases decisions over cell phones. They affected the sale of cell phones.
I tend to agree that the CITA is somewhat similar to the AHA.
I'm sorry, you said you.
I tend to agree
Okay.
that it's
So
somewhat
do I then. So we're
understood on that
okay.
piece. I think we might be on the same page, but I have a follow-up, I guess, to the question that the Chief Judge asked you about how Dahlgren is analyzed. Can you point me to the part of Dahlgren where the trial judge works through the trade secret analysis and says, here is why the various things that you're referring to here don't qualify the CTIA, if I'm getting the initials right. CITA, thank you, as a merchant under that part of the statutory text?
Right. So if you look at Dahlgren, which I have the Lexis thing, so I'm at 210 DC Superior Court 9, and I'm looking at star 38 to star 42. And it starts off by talking about Howard, where the merchant, and I'm now at, see, 38. And it starts off by saying plaintiffs are not allowed to see to sell cell phones directly, but does say it does so indirectly by operating as a marketing arm of the cell phone manufacturers. Now, if we stop right there.
That's not on the trade secret part yet.
That's
So
not.
I'm waiting for the part where we
and
get
AHA. And then it goes on to discuss Howard and how its merchants is not limited to the actual seller of the goods or transaction, but includes those connected with the supply side of the consumer transaction, which is where this case is.
I guess I'm still waiting for the part of Dahlgren where the trial judge refers to the trade secret part of the statute and analyzes why the allegations against Dahlgren didn't fit under that part of the statute.
Right. So if you go to star, what I'm on star 40 with the paragraph that starts the quarters of the opinion, however, right before it says star 41, it says merchants who took part or carried out a trade practice or other persons may be deemed legally responsible for the trade practice.
Sorry, where are you?
Right before star 41. I have it highlighted. I don't have a clean copy for the court, but I can. Right before star 41.
On page 41 of the slip opinion, and I'm not.
It's right before, it's at the end of 40, right before 41 on mine. Okay, and then.
At the top of page 40.
Yeah.
Which just notes that Howard there's a quote from Howard that uses those terms.
Right.
Is what's there.
Right. And then,
is it the part where the trial court says, and here is what I think a trade practice means?
No, but they considered it.
Well, they quoted words including it from Howard. That's true.
Correct. But they did not find, after they quoted it, that it was applicable to the CITA. If the CITA cannot be liable under the CPPA, the American Heart Association cannot. I'd ask that this court not allow the CPPA, which has been interpreted consistently over the last 45 years, starting with Howard, Dahlgren, Jefferson. I would ask that you not twist it and allow Animal Outlook to essentially widen it so that anybody who's at all attached to the sale of a consumer good is liable.
Well, I don't quite see why a holding that the current complaint plausibly alleges AHA status as a merchant would mean that anybody who had any connection to the supply side of a transaction would be a merchant. That seems like a pretty
Because Your Honor,
substantial leap.
because Your Honor, if you look at Dahlgren, you look at Jefferson, you look at Howard versus Riggs, there's a limit. If it's not Mrs. Kelly who makes the recommendation, if it's not CETA, if it's in Jefferson, it's the drug manufacturers. If it's not those people, then certainly the analogy is that the American Heart Association, which is heart check mark, is not liable.
Can I ask you how you think the opioid cases should come out? So let's assume, and this is a variant of them, but assume that I am the manufacturer of a product, but I don't directly sell it to anybody. I sell it to other third parties who ultimately then make it available to consumers.
I think manufacturing matters. I do. I think manufacturing matters.
You don't think that's too far up the supply chain, even if there are 2 or 3 intermediate sellers?
I think it's a closer question than a heart check mark on a label. I would argue that it's not. I would not be surprised if this court found that it was, because it's a manufacturer. Although they don't sell, they certainly come closer to selling because they manufacture. And I think that's a distinction with a difference with regard to the American Heart Association, because the American Heart Association does not sell. They do not manufacture. They do none of that. They put their heart check mark on there.
So we've taken you pretty deep into the merits and we've already taken you over time, but I'm interested in hearing, because one option we have is to say, well, you went outside of the record.
Right.
This should have been looked at under the summary judgment standard and send it back and not make a decision on the merits ourselves and have the trial court really analyze this. We went into this with your opposing counsel. What's your response on these questions of having gone outside of the record and the procedural?
We addressed that on pages 26. I kind of thought that this would be a question today. So I have a 10-part answer that I'll tell you takes 2 minutes and 45 seconds. So I'm not going to, so I did it this morning, so I'm not going to bore you with it. But we addressed that on pages 26 to 29. And I think it's important that this court can affirm the Superior Court by, as this bench knows, just referring to the complaint. And what's important that Animal Outlook pled. First of all, it alleges that the consumers in the District of Columbia purchase beef in grocery and retailer stores. It says that AHH markets its heart certification program to producers and manufacturers of beef. And I'm at Appendix 315 and 319. Then it alleges that American Heart Association did not affix the health chair mark to those materials. They don't affix them. The seller does. The beef manufacturer does. Then it alleges, that's at 311. Then it alleges that American Heart Association authorizes companies to use the mark on their beef products. That's at 319. Then it alleges that American Heart Association allows certain companies to affix it to their products. Then it alleges that American Outlook specifically pled in their First Amendment complaint that American Heart Association engages in a business practice. However, the producers and manufacturers of the beef are the decision makers. They decide if the mark is going to go on their product. And then finally it alleges that the direct consumer of the transaction is the purchaser of the beef. And that's at 315. Which is why I think this court should, if the court does not agree with the consideration of that the lower court gave, and the court believes that the lower court should have converted the 12b6 to Rule 56, to a motion for summary judgment. If this court believes that, you don't need to get there. And I would urge the court not to. I would urge the court to review the First Amendment complaint and see what was pled. My old law school professor made me write at the top of every appellate argument, remember standard of review. It's a de novo review, as this court well knows. And I think when you review with the allegations in the First Amendment complaint, they demand that the CPPA not apply to the American Heart Association. because I believe that the American Heart Association's position is at least a step, and I would argue 2 or 3 beyond what could be considered a merchant and well up the supply chain.
Thank you, counsel.
Thank you, Your Honor.
Ms. Huggins, you have reserved a few minutes for rebuttal.
Yes, just a few things. First, as Your Honors recognized, our first choice is to stand on the current complaint, and so the amendment issue is not necessarily at issue. The second would be we did make a request in the opposition, and the second choice would be to amend. Regarding Howard and Dahlgren, there is no other case. I think this is a case of first impression in which a third-party certifier has been this involved in a product. So again, unlike Dahlgren, where a trade association is making general statements to the consuming public, here, American Heart Association is actually testing a product, going out to the consuming public, saying only buy products that have our label on it, and then coming back and licensing their label onto these physical products that are bought by the consumer at the point of sale. There's no similar case to this. There's none of the trades association cases, Dahlgren, Praxis, have a entity that involved in the point of sale. Regarding the question of decision making, who decides whether the label is put on, this is a licensing arrangement. Granted, we don't have discovery on the full extent of that arrangement, but presumably AHA could revoke the license, and so it does have ultimate control on whether the label appears on a product or not. And the final point I wanted to make, opposing counsel said the product, the certification is only whether the product meets government standards. One of the allegations is in the complaint is that AHA does not disclose that that is all that the label is. They act as though the label has a higher standard than the government standard. Obviously, to sell beef at all, you need just to meet the government standard, but AHA is only putting their label on certain beef products that are certified by them, pay this fee, and they're acting as though it meets a higher standard than the government standard.
And could you just reiterate what the relief is that you seek?
Yes. So as you mean the relief here on the appeal or in the
Yes.
complaint?
Here on appeal.
On appeal, we would like to have Your Honors, I believe we asked for it, and let me just make sure I get the language right. We want to go back to the trial court and stand on the current complaint. And in the alternative, sorry, let me just. Reverse the trial court's order sustaining the motion to dismiss and direct the trial court to vacate its order sustaining the motion to dismiss so that Animal Outlet can proceed on the complaint in the trial court. Alternatively, direct the trial court to vacate its order sustaining the motion to dismiss and enter a new order sustaining the motion to dismiss with leave to amend. So the first option is the one that we prefer.
Thank you.
Thank you, Your Honors.
We'd like to thank both counsel for your briefs and arguments, and we'll take the matter under advisement.
Thank you.
Thank you.
It would take me a minute.
All right. Our second case today is in re Michael Allen Yoder and in re MARNITTA King, consolidated cases. All right. I think we begin with Mr. Yoder today, or is it?
Good morning, Your Honors.
That's the party's understanding of how you all were going to proceed, correct? Mr. Yoder, then we'll hear from Ms. King, then we'll hear from disciplinary counsel, right?
I didn't know which side went first in these hearings, but I'm really happy to start.
Okay, would you like to reserve any time for rebuttal, Mr. Yoder?
2 minutes, please, Your Honor.
Thank you.
So the issues before the court today are focused in on a issue of first impression, which is whether in a situation where there is a contest over a reinstatement provision, whether that provision should be applied based on a condition precedent that the individual is reinstated in the original jurisdiction first. And here I'm arguing as to, in a generality context, the Rule 11, Section 11 provision in the statutory text doesn't in any way have text that states that it's a mandatory or that it's a presumption standard. Rather, the distinction here is between the disciplinary action and the means by which an attorney can seek reinstatement. So I'm bifurcating out the punitive aspect of it versus the protective interest, which is sought to be effectuated by the reinstatement provisions here. So DC has its own specific rule under Section 11, Rule 16, that effectively prohibits someone from being reinstated without having gone through a proper vetting or character and fitness, which looks at the 5 various factors of the nature of the conduct, the way that they've accepted it, whether they, at the time of seeking readmission or reinstatement, are of good moral and character fitness and capable. So the District of Columbia itself already has the measure in place that protects against any concerns in the other jurisdiction, whereas on the inverse side of that, there are certain circumstances in which it could serve as a unduly punitive or prohibitive vehicle that would bar someone from seeking reinstatement in the District of Columbia by making that a presumptive or an otherwise steadfast rule as a condition precedent. And I think the court should look at it on more of a case-by-case basis.
All right, so in looking at it on a case-by-case basis, we do have some cases in our jurisdiction where we've considered the question of whether or not reinstatement in the originating jurisdiction is required before reinstatement in DC can go forward. And typically, for example, in cases where there's a fitness requirement, we have tended to require reinstatement in the originating jurisdiction. And here, where your discipline in Virginia is equivalent to what would be disbarment in DC, certainly that's a circumstance under which, on our case-by-case basis, we have prior cases where we have required reinstatement there. Are you saying that if we follow a case-by-case analysis here, that we would reach or should reach a different decision in your discipline?
I am, Your Honor, because I think that the primary distinguishing factor is that there was not a contest over that condition of reinstatement being condition precedent in the Kanu or the Cater cases. Both of those cases in which there was no contest as to whether that be a condition precedent. The second level of that is both cases emphasize the condition of reinstatement as to serve to protect the public interest within DC as opposed to be punitive. So here, whereas an attorney is, and again, this is focusing more so on, like I said earlier, the bifurcation, not necessarily of the discipline itself, but more so the vehicle by which someone can become reinstated. There are certain jurisdictions that may have, for example, in a circuit, I'll give us an example where it could be a valid reason, which would be if there's certain monitoring mechanisms that a jurisdiction would have that the District of Columbia otherwise would not have throughout the period of suspension or disbarment, that would be appropriate. However, if someone were to be required to, as a condition precedent, get reinstated in a jurisdiction where they had a license but hadn't practiced for 20 years, and they had to go through the entire cost and all the process just to get reinstated in the district, which is the only jurisdiction they practice in.
But neither of those situations are your situation.
Correct, Your Honor. And the reason I'm trying to distinguish here is, without going into the necessary aspect of the conduct itself, I have no intention of ever practicing within Virginia, and I can also, you can certify that with an affidavit of non-pursuit. But in order for me to be able to potentially, if I were to decide that I wanted to practice law again, the condition itself as a condition precedent would effectively foreclose the ability for me to seek reinstatement in the District of Columbia without going through a jurisdiction that I otherwise will not practice in again.
Do you view that as sort of dispositive in the sense that if, assuming it's established with adequate certainty, for example, as you're suggesting by an affidavit, that an attorney who was disciplined in one jurisdiction in a way that would require reinstatement there, if the attorney wanted to practice there and then was subject to reciprocal discipline in DC, signed an affidavit saying, I have no interest in practicing in the original jurisdiction where the initial discipline was imposed. Do you think that just ends the discussion? And if that's true, then the court should not impose sort of multiple reinstatement requirements where first you have to get reinstated in the original jurisdiction, or do you think that's just a factor to be considered?
I think it's a factor to be considered, but I also think it's unduly duplicative in the sense that you have the Rule 16 standards to be reinstated in the district here. So it's not as though that's the only gatekeeping mechanism to ensure the character and fitness is appropriate to protect the public in the district. But also the second level of that is the non-pursuit. I would also argue that the condition would get triggered if they were to seek reinstatement. You know, the condition is protected in that sense too, where it's not just that I don't intend on seeking reinstatement, it's if they were to try to, then that would require that go through before they would be able to be reinstated in the district as well. Because I understand the court's concern if someone were to certify that they weren't intending on practicing in a jurisdiction, well, if they changed their mind and went to practice it, the court could order that if you seek reinstatement in the original jurisdiction, you have to be admitted in order for you to be able to seek reinstatement in the district as well.
Quite sure how that would work practically. I guess it would depend on the timing of events. But if, let's say, leaving someone in your situation who originally did not plan to try to be reinstated in the original jurisdiction, then came to DC, got reinstated in DC, and then decided to go back to the original jurisdiction and try to get reinstated. I mean, there's already been reinstatement in DC. Are you saying that that would unravel the reinstatement in DC, or that if the hypothetical person in that situation failed to get reinstated in the original jurisdiction, that would negate the determination in DC reinstating the person? I'm just not quite sure how that would work mechanically.
Well, if that were the order of operations in that sense, I would say that would be there would be a discrepancy within the applicability as to how the Rule 16 was applied for the attorney to be reinstated in the district and not be of good fitness or character and then fail to be reinstated in the other jurisdiction if it were held unless there were significantly different standards of what constituted character or fitness to be. If you got admitted back into DC and you were found to be of sound character and fitness, because it's a rigorous process as opposed to just it's not a presumptive readmission, you have to petition for it and go through that process. So I think if you went in that order of operations, then the district would have had plenty of opportunity to ensure that that individual was fit to practice again in the district here.
Well,
So
we certainly have, established case law in our Roundtree case regarding the factors that we should look at when considering reinstatement. But the first factor that we look at is the circumstances of the misconduct in the other jurisdiction. So it seems to me that just saying you don't intend to practice in Virginia by itself is not enough to condition reinstatement in DC. I mean, are there other reasons that you would argue counsel in favor of you being reinstated to practice in DC? Because you seem to be suggesting that we ignore the first factor of Roundtree, which is looking at the circumstances of the misconduct in the originating jurisdiction, and that we only focus on forward-looking things. What have you done since you were disbarred in Virginia, and almost ignoring the original reciprocal discipline?
well, in the
To me,
Canada
that we,
decision,
in other words, I'm trying to pin my question down a little bit more. I'm not persuaded that the fact that you think now that you would not want to practice in Virginia ever again is enough for us to then move forward with analyzing whether you are fit for reinstatement in DC. What else should we be looking at?
well, that was predicated on, I guess, two separate principles there. The first being the Cater decision stating that when looking at reinstatement, it's to quote, serve requirements of forward-looking assessment, not extraterritorial enforcement. The second level of that is I'm not trying to blur the line over accepting responsibility by relitigating or hashing out the nitty-gritty logistical aspect of what I've highlighted in the brief of the distinguishing.
But you do seem to be making some arguments in the briefs that back away from your affidavit accepting disbarment in Virginia. You seem to be suggesting it was the press of time, the expense of litigating that, as opposed to accepting full responsibility for the circumstances that led to the disbarment in Virginia.
The affidavit was it was a matter of pragmatism, saving on expense, and also accepting responsibility in Virginia. The second layer of that too was that when looking at the Virginia rules and then comparing the Virginia rules to the District of Columbia rules, they are not identical rules in the sense of mirroring one another. So when I looked at
Can I ask you, before you get to the asymmetry point, just back on the matter of pragmatism point, is it your position now that things that you said in that sworn affidavit are false and that you said them falsely for pragmatic reasons? Or do you think everything there was true and now you're elucidating it? Because if it's the former, that seems worrisome.
No, I would say it's the latter, Your Honor, but I think even if every statement in that affidavit were to be proven true, and I'm not saying that, I'm saying the hypothetical, not as though I'm arguing it. I'm taking
Let me
that
just ask you,
position.
let me pin my question down more concretely. Is it your position now that anything in that affidavit was knowingly false? Or is it your
No.
position instead, everything that is in that affidavit we can take as you believed it to be true at the time you said it, and we continue to treat it as true?
Yes, I would agree. I would agree with the latter of that. Yes, I believe I would. And my only position was that, for example, looking at the pro hoc vice issue, yes, each aspect, each factual allegation there was true. Everything in the affidavit, but because everything in the affidavit being true does not mutually constitute a violation in DC either.
I mean, again, I get the asymmetry point, but just back on the affidavit didn't just admit some facts. It also admitted some legal conclusions that in fact, the conduct there was a basis for discipline in Virginia. And I mean, are you saying that to the extent the affidavit swore that certain legal conclusions were true and accurate, that they're not, that was wrong, that was incorrect, and that maybe you didn't understand it was incorrect, or that you knew it was incorrect, but you decided to swear to it anyway for reasons of pragmatism?
No, everything in the affidavit was true, and I still stand by that. I think
Including the legal conclusions that you agreed to by signing the affidavit.
Yeah, like the statement that there was sufficient evidence that I wouldn't be able to defend on the allegation. Yes, I agree with that, and I take responsibility for those things. I'm not in any way trying to shape shift off of accepting that, and that's why I'm mainly focusing on the provision regarding the reinstatement aspect, not necessarily re-arguing or
But
hashing out the conduct
I
itself.
guess my question was, I know you want to sever and look separately at the discipline that brings you to DC, which is in a reciprocal discipline case. You want to separate that from the reinstatement piece. But my question related to the standards that we typically use in DC under the Roundtree case to consider reinstatement. And those standards don't draw such a stark dichotomy. In fact, a part of those standards is, number one, the circumstances of the original discipline in the originating jurisdiction. And I guess in your mind, you want us to disregard that or not focus on it because you no longer intend to practice in Virginia and only look prospectively. And I guess my comment is I'm not persuaded. I think there should be other factors that we can consider that you may want to argue. And I guess I'm asking if there are any other reasons other than the reason that you don't want to practice in Virginia anymore that you should be reinstated here.
And I apologize if I wasn't clear in that, Your Honor. I'm not saying to disregard the underlying circumstances and facts. I was trying to bifurcate that out to say that I wanted to focus the argument on the specific question asked, not bring up or try to relitigate to back out of the affidavit. That's why I was trying to distinguish at the beginning. So I'm not in any. I apologize if I did not articulate that clearly. So no, I do think that that first roundtree factor is something valid and it should be considered. I just would submit that it be considered in the context of the DC rules as well, not necessarily under the Virginia rules, because the predicate basis of this is that the board respectfully argues that the Virginia rules control the presumption that of imposing reciprocal discipline. So at the same time, it should theoretically apply the same principle that it applies the rules uniformly. Whereas it's here asking to apply part of it, but not another part of it. And I see that as, it's if we're going to apply Virginia rules, apply all of them as opposed to applying part and not part of the other. And in DC, I think it should be focused on the rules of professional conduct in DC. That is what's regarded.
Thank you. You can reserve your time for rebuttal, so we'll come back to you, Mr. Yoder.
Your Honor.
Thank you. All right, Ms. King, are you ready to proceed?
Thank you. And good morning. Thank you for giving me this opportunity to speak before you. I've missed being in court, so thank you. I first want to talk about.
You want to reserve any of your time?
Sorry, yes, I do.
Okay,
Thank you.
we'll reserve 2 minutes.
Thank you. I do want to talk generally and then more specifically. So generally, I believe we are here to determine whether or not we should require reinstatement in another jurisdiction on being reinstated here in DC. That's clearly the issue. And I argue that it should be on a case-by-case basis. There should not be a general rule. I think even the consolidation of these cases shows the very issue at play here, that each individual case can be very different, and I believe that the court should, on a case-by-case basis, determine whether or not that candidate is fit for reinstatement. And
Well, what we have done in the district prior to these 2 cases being consolidated is essentially what you're suggesting, considering these kinds of cases on a case-by-case basis. But when I look at some of our prior cases, where we have tended to condition reinstatement here on reinstatement in the originating jurisdiction are cases where there is a suspension, as is here, with a fitness requirement, as are the circumstances in your case. So why, if we are considering your case on a case-by-case standard as opposed to under a generalized rule, presuming that reinstatement is required in Maryland first, why would your case not warrant a requirement that reinstatement in Maryland take place before being reinstated here?
in Maryland specifically, they did give me the permission to apply for reinstatement after 6 months with certain conditions that DC has now interpreted to be fitness-based. But those conditions in Maryland were probation for a year. Those conditions were a practice monitor. Those things, as the court found, weren't because there was any dishonest motive, any selfish motive. It was because I failed to meet the standard at the time of an attorney. And they did look at some of the other factors that minimized that, but I did fail at that time, and I accept responsibility for those failures. But when you look at reinstatement here in the District of Columbia, you have to look at the breadth of knowledge that the District of Columbia has about my reinstatement and fitness versus Maryland. I mean, quite honestly, in this case, I have practiced hundreds of cases a year since 2007, although I've been here since 2003, but I want to talk about from 2007 until the present. As a Criminal Justice Act attorney, the District of Columbia knows that I'm certified every year as far as having to do CLEs. I have to, every 4 years, apply back to the court, and several judges and a panel review all of my work product. Literally, the 2 cases that have brought me to Maryland is less than 1% of the number of cases that I have tried over the course of my career. Is it any less that I failed even one citizen or one person? No. I don't want to fail anyone. And if I've learned anything, it's that personal things that happen in our life, we have to pay that more attention because we have such a duty, right? And so in answer to your question, yes, I believe there is a fitness aspect that we have to look at, but DC has the ability to look at that fitness.
How would we, I guess, logistically, part of the requirement in Maryland was probation in Maryland and a practice manager. Are you suggesting that you're subject to that, so someone in Maryland would be monitoring your practice, that we should duplicate that effort here as opposed to waiting until those conditions have been satisfied in Maryland?
He is the head that wears the crown. I would have to be duplicated. I would have those efforts duplicated in both places. And I would understand why, because things may be different in DC than in Maryland. I've already prepared, and I am applying for readmission in Maryland. I'm pending my application currently. But should a person have to apply? I don't think so. I think if I would have chosen to never apply to Maryland, I should be able to apply for reinstatement to DC. I do believe that those are two exclusive things. I think to put a per se rule in place makes it a requirement to apply for reinstatement in Maryland. And Maryland has never said that. They did not say you have to reapply in 6 months. It's a permissive thing. I am clearly, I don't want to confuse anything. I am applying for reinstatement, and I do hope they reinstate me. But separately.
Can I ask you a question? I want to make sure I understood a part of your answer to the Chief Judge's question, which was about duplication. I had understood that the Office of Disciplinary Counsel here was seeking as the suspension, not duplication of any sort of, practice monitoring or any of that here, not duplicative sort of monitoring, and then reinstatement first, if possible, in Maryland, and then you can come to DC and try to be reinstated here. Were you suggesting that you thought that it would be, the way it should work is that there should be duplicative practice monitoring, kind of the conditions of your Maryland probation should be replicated in DC, and you should have to comply with them in both jurisdictions? Is that what you're suggesting?
So I've had to step outside of myself. Now, for me, I would love to just have to apply and do things for Maryland and just come back to DC. But if I were honest very clearly on what should be for everyone, I believe DC would be well within their rights to require me to meet whatever criteria they believe under the Roundtree and otherwise for me to be reinstated. And if
Again,
that
just
included—
to clarify something that I think I have in mind, at least, and maybe I'm misunderstanding things, a distinction between whether a condition of your suspension, as it is in Maryland,
Yeah.
is that you do some various things in Maryland, monitoring and the like. So that's not about reinstatement. I mean, that's a prerequisite to reinstatement, but it's a condition of your suspension in Maryland. At least what the Office of Disciplinary Counsel was asking for in DC, what didn't seem to be that. They were just asking be suspended in DC. Presumably you'll go satisfy the Maryland authorities and do what you're supposed to do in Maryland, and then you'll go and you'll get reinstated in DC. Then you'll come to DC and be reinstated. And the reason, as I understand it, the Office of Disciplinary Counsel thinks that's a better system is when the issue of reinstatement arises in DC, DC will have, rather than having to kind of redetermine, call witnesses from whatever happened in Maryland with respect to your, monitoring and the like, they'll be able to rely on the determination that is made in Maryland, which has better access to the relevant information. And what they don't want to do, if I understand it, is to instead, if they're going first, when they get to reinstatement, they're going to have to look into how your probation went in Maryland. But instead of having the benefit of Maryland's ruling on that, they'll have to kind of prove all that up themselves, figure it all out themselves. That's what I understood. But you're suggesting that you, at least leaving aside your preference, you're suggesting that you think it might have been appropriate for the Office of Disciplinary Counsel to not only seek your suspension, but to, I mean, I know you don't think they should be requiring you to get reinstated in Maryland first,
Right.
but it sounds like you don't think there would be an objection had they said, which they haven't yet said, at least as I understand it, that your suspension in DC should require sort of parallel monitoring and conditions of suspension that are similar to the ones in Maryland. Is that right?
That's correct, because if I chose to come to DC first at the end of the 6 months, DC should be able to make their decision and say, okay, well, you haven't done those things yet in Maryland, so we want to make sure that you are fit to come back here into DC. So we do want you to be monitored. We do want you to serve a year of probation. And in a general sense, I could understand that, because I have yet to, I either am never going back into Maryland, or Maryland's process just may take longer. So I can understand DC having to protect DC residents and DC court protocol to make sure. Now, they didn't ask for that, but if they did, I think my argument has to be consistent, and DC has to do what DC needs to do to protect DC. And I'm prepared to do what DC thinks I need to do. I believe they have a wealth of knowledge to be about me specifically. And
I take your point that on some reinstatement factors, DC is in a superior position in terms of getting access to information. That's one of your lines of thinking. Their point has been focused more on some components of it as to which they think Maryland would have the advantage of better information. And it seems as though, depending on the case, in any situation like this, it might, it might be that all of the information is more likely to be in one place. It might be that it's mixed between multiple places. But here you agree there's, unless DC required parallel monitoring, there would be better information about some of the components of reinstatement in Maryland than there would be in DC. Although I know your point is on other factors of reinstatement, the information is better in DC. But do you agree that at least on some topics, if DC isn't requiring parallel monitoring, Maryland would have better information?
actually, in my case, no. I believe it's like a relationship. Which of my paramours knows me best? DC knows me best. Unfortunately, I've started in Maryland first, and I love Maryland. I am a Marylander. I love DC too, but I'm a Maryland DC attorney. I just practice here more. I'm here on a consistent basis. I am regularly reviewed by the court. I don't think there's one level of fitness that anyone could look at and say that between the two, that Maryland knows me better than DC.
So why wouldn't that be just a great argument to rebut a potential presumption?
I'm sorry, I didn't hear you.
I said, so why wouldn't that potentially just be an absolutely great argument to rebut a potential presumption?
Well, I think it is a good argument to, because there should not be a presumption that reinstatement should be in Maryland first, because, and it should be dependent on the case, because someone else's case could be very different. And so when you look at that case, and in fact, the committee was very clear. The record is extensive in my case. This is not a case where there was any confusion about what led me to be suspended. They had the transcripts, they had the mitigating factors, they had all the information. And so this is not a case where there was anything left for them to figure out for Maryland. The transcripts were open. And so for that reason, DC is not lacking any information in this particular case. The question clearly is, A, did she acknowledge what she did? And I did. Has she, and how serious was it? They know how serious it was because it was very detailed. The judge made findings, the court made findings, whether I took exceptions or not, they're there. And now there was some I'm not gonna say confusion. There has been a dispute, I guess, on my level of remorse. And I think it's just in writing, it's not coming out well, because I did give a reason of what was happening in my life, but that does not mean I'm not remorseful. I've never wanted to fail any particular person. And the fact that I failed the bar as a whole, and in DC, I feel like I have failed the Criminal Justice Act panel and all the judges that relied on me. I left behind hundreds of cases when I was suspended. And I didn't want to do that, not to the people and not to the court. And so I am remorseful. I believe that reinstatement should be on a case-by-case basis. The practical consequences of requiring me or anyone to first apply to that other jurisdiction is would cause basically an indefinite suspension in DC. And that was not even what was intended in Maryland. What was intended in Maryland was for after 6 months for me to be able to prove my fitness and to reapply to that jurisdiction. So I am asking for the court to adopt a more case-by-case approach in these scenarios. I
All
thank
right,
you.
thank you. And we'll reserve your 2 minutes of rebuttal. All right, Mr. Metzler?
Thank you. May it please the court, Jack Metzler for the Office of Disciplinary Counsel. I just want to be clear as to our position based on the previous argument. We aren't asking for a per se rule. We are asking for a presumption that this sort of condition that the attorney be readmitted in the original jurisdiction be applied when the original suspension or disbarment in DC is based on a reciprocal matter.
Ask you just step back and try to figure it out conceptually, because I'm struggling with an aspect of it that hasn't really surfaced yet. So do you agree that generally there is a presumption in favor of reciprocal discipline, A, and there are exceptions, otherwise you get reciprocal discipline, and that reciprocal discipline is understood to mean identical discipline. And so if you want non-identical discipline, you need to fall within an exception. Is that the common framework that we're working from?
Generally speaking,
Where does generally fit in?
so I don't want to go too far into like the literalness of the word identical, in that the court applies basically a functionally identical. So both of these cases involve form of discipline that the District of Columbia doesn't have.
Good qualification. So I'm with you on functionally identical, and that's really where I'm headed, is to try to understand what identical means, or functionally identical, good improvement discipline is. And so, I mean, if let's say where it's simpler and it's actually identical in terms of suspension, let's say the foreign discipline imposes a 2-year suspension with what they're calling reinstatement, and they apply factors that are like ours. So it's, really just not meaningfully different.
Sure.
And so one question that I struggle with is, obviously, this is why functionally is a good addition. We don't impose identical discipline in the sense of saying you can't practice law in the foreign jurisdiction. It's identical here.
Right.
So I get that. And so it seems like you would think that what at first blush would be identical discipline would be, you're suspended for 2 years and don't practice law until you come back and persuade us that it's appropriate for you to do so. It would seem like the functionally identical discipline at first blush, at least, would be us saying, the disciplinary authorities here in the court saying, don't practice law here for 2 years, and then come back and try to persuade us that you are fit to practice law here. That seems like it would be functionally identical. Do you agree do you agree? Are you with me so far, or have I
I'm with you
lost
so far.
Okay. Here's where I start getting into where I feel like my thoughts are somewhat different from your position. If you'll pardon some basic algebra, generally, if x is some number other than 0, 1x does not equal 2x. And so it feels, just at first blush, kind of naively looking at it, it feels like imposing the discipline here, which is not only do you have to persuade us that you're fit to practice here, just as you had to require to get reinstated them, you have to persuade 2 different entities that you're fit to practice law in 2 different places. That doesn't feel identical. That feels 2x rather than x. And so that's where I struggle. It seems to me that, if you think of it that way, then I think the logical consequence would be that ordinarily DC would reinstate the identical discipline, functionally identical, would be reinstatement in DC, and that's all you need to do in order to practice in DC. And if the Office of Disciplinary Counsel wanted to persuade the court to do something different, it would need to fall within an exception.
Sure.
What's wrong with that way of looking at it? Which would, again, it's not a presumption in your favor. In fact, it's a strong presumption the other way if you would routinely like to have extraterritorial reinstatement as a predicate. But it's not a flat rule either, because where you can make a good case for it, if you think there's an exception that would apply, you could try to persuade the court to impose it. So what's wrong with that way of looking at it?
So I think the way to start that analysis is to consider the difference between reciprocal discipline and an ordinary sort of original disciplinary matter in the District of Columbia. And there are two reasons sort of behind the idea of reciprocal discipline. One is that an attorney who is licensed in DC is responsible for the conduct that they engage in everywhere, in DC and elsewhere. And then the second reason is basically one of efficiency and comedy, which is when an attorney is disciplined in another jurisdiction, this court respects and relies on the findings of that original court when it imposes discipline here. We don't start from scratch. We don't say,
those are both really good points. They lead me to, I mean, I agree with everything you just said entirely. They pose a question about whether the first theory I was describing about what functionally identical discipline should be for this purpose in the context of reinstatement should be reinstatement here. Because they could lead you to the view that actually functionally, the overall logical structure of reciprocal discipline is subject to exceptions. We're relying on the determination of the original jurisdiction that someone needs to be sanctioned in whatever way they sanction. And one could say that the logical structure of that means we should do the same about reinstatement. And that we should, instead of having our own reinstatement, our independent inquiry into reinstatement, we don't have a fully independent inquiry into whether there should have been suspension. So what we really should do is we should think of functionally identical discipline as reinstatement in the originally disciplining jurisdiction. I get that line of thought too, and that seems to be another perfectly reasonable possible answer to the question. That doesn't necessarily get you to the idea that you get 2x as opposed to which 1x you get as functionally equivalent discipline. So one question I have about that is, assume for a moment that the court ends up concluding that whatever the answer to these questions is, it's not functionally equivalent, functionally identical discipline to require reinstatement in two places. And then if the question is, okay, then which place should be viewed as functionally identical discipline, reinstatement in the disciplining jurisdiction originally or in DC? Do you have an answer to which one you think would be the right? I know you don't agree that should be the choice, but if it is the choice, do you have a view about what the better answer would be? Again, all of it would be subject to exceptions because you could always come in and say whatever functionally identical discipline is as an original matter, there's a case to be made for something different in a given circumstance. But if you had to pick only one horse, do you have a horse that you would pick?
so I suppose, because I don't want to avoid your question, I suppose given that choice, I would say the original jurisdiction that adjudicated the misconduct would be the one that should first get should be the same one because they have better information to evaluate reinstatement. But I do want to attack the premise just a little bit. And I don't know if this is where you're coming from when you've said many times, identical or functionally identical. And I'm not sure whether you are sort of placing like a heavy reliance on the part of Rule 11 of Section 11 that talks about the presumption of identical discipline. So I would say to the extent that is the problem, I would look at Rule 11, Section 3, B or C, I think, which says that in any order of suspension or disbarment, the court can impose, any reasonable condition. So I don't think the court is bound by the word identical in Section 11, such that
Sorry, say again the section you were referring to.
It's Section 3. It's B or C of Rule 11. And it's a separate paragraph, and it just says in any order of suspension, any disciplinary or suspension or disbarment, the court can impose reasonable conditions. And I would say this
reason you don't think, or do you, that that provision allows the imposition of non-identical discipline without meeting the exceptions in Rule 11?
I do think that.
You do think that?
Yes. I think when it says in any order, it
Function of the exceptions. I don't understand what the function of the exceptions is.
the function, so the second point about reciprocal discipline is that is actually similar similar to this question that you have before you involves two aspects of the disciplinary system, both which share one feature, which is that the burden in those is the opposite of how it usually is. When you have a reciprocal discipline, the attorney has the burden to prove by clear and convincing evidence either that they shouldn't be disciplined based on the original order, or that the discipline should be different. And likewise, on reinstatement, the baseline is that the attorney won't be reinstated. There's no right to be reinstated. They have to prove their fitness by establishing the Roundtree factors. So in both of these cases, in both of these situations, you've got the burden is on the attorney's side. And so the function of the exceptions are so that the attorney can, or to say what the attorney has to show in order to avoid the imposition of reciprocal discipline.
The exceptions are available to the disciplinary. I mean, they're available not only to attorneys. They're not a one-way ratchet. It is not unusual. I mean, it's not common, but it's not anything but unheard of for the Office of Disciplinary Counsel to come in and say, this is a reciprocal discipline case, but we fall within one of the exceptions and we think there should be different or higher discipline, or sometimes the determination would be agreeing that there should be, but they're available to both sides. Is that right?
But I think if you sort of look at the rule, I think that the general case, the mine run of cases, is that an attorney is disciplined somewhere in another jurisdiction, and they would like not to be disciplined or not to have the same discipline happen here. And so, even the first exception is due process. You would think that the court should independently look to make sure that there was due process, but it falls in these exceptions that require clear and convincing proof that of due process. The default position is that the court, again, respects and relies on the adjudication that was from the original jurisdiction.
I understand that, and it's the general comments you were making seem to support a line of thinking, which is that should be done in reinstatement as well, and that just as this jurisdiction respects and gives heavy weight to, under very stringent exception requirements, to the determination of suspension and of violations and sanction that includes here suspension and reinstatement in cases that are like the ones we're discussing now. It would seem that one way of looking at it is the logic of that should be the same should be true with respect to the foreign jurisdiction's determination about reinstatement, and we should just treat that as the functionally equivalent discipline. And if for some reason the Office of Disciplinary Counsel thinks there are extraordinary reasons to not do what we do at the back end, what we did at the front end, then they can make a case for that.
Right. So let me address that. I think in the mine run of cases, and this definitely happens when someone who has been readmitted in the original jurisdiction comes here, they have a pretty strong basis for readmission, and often we do not oppose it. Our process is that they apply for readmission, and disciplinary counsel says whether we oppose it or not, and often we don't. I think one of my colleagues told me this happened, in the last few months. But it's also true that there could be reasons why we think, despite the original order or the original readmission in that jurisdiction, they should still have to go through the process here. And I would direct the court to its decision in Inree Berger, where they talk about this very subject. So in some jurisdictions, they have a process of summary readmission, so long as bar counsel in that jurisdiction doesn't object. Well, we might take a look and say, we would have objected. We're not so sure that establishes the proof.
But doesn't that, what you just described, seems to counsel against a presumptive rule, which is what I understand disciplinary counsel and the board's position to be. Here, if we look at the two cases start with Ms. King's case. You have a fulsome record in Maryland about what the basis for their discipline was and what requirements they put in place, including she can seek reinstatement there after 6 months, if she chooses to. What else would you need here to consider reinstatement that you don't have from the Maryland disciplinary record or from her record of practice here? I mean, that seems to be a situation that brings into play some things that might be considered exceptions if we had a presumptive rule in favor of requiring reinstatement in the original jurisdiction. So I guess I don't see how a presumptive rule requiring reinstatement in the other jurisdiction helps one way or the other, because the questions that we would still have to confront here are, do we have enough information to understand why discipline was taken against this attorney in the other jurisdiction? And do we now have enough basis to see why they should be readmitted here? I mean, it seems like there could be a certain redundancy in requiring the attorney to seek readmission when the discipline in the originating jurisdiction doesn't require that in either of the cases before us.
So I take it I hear two questions
There are probably two or three in there.
Right.
So
Let's start with two. So the first question, I think is whether in the general case, a presumption, we're suggesting a presumption that would be rebuttable, and that where the attorney can come in and say, look, for these reasons, DC is equally capable of adjudicating whether I should be readmitted, and that's one thing, and we agree that that's what we're asking for. We're asking so.
do you need that? Do you need that in order for DC to determine whether or not someone should be readmitted?
Do we need what, the presumption?
That presumption in place.
So I think the
you do
reason
that anyway.
Right. The reason we suggest a presumption is these cases come. I mean, as a practical matter, someone who comes in is going to have. They're going to say, "Well, DC can handle it for this or that reason," and what we're I guess what we're suggesting is when the panel is not this one that has thought hard about this, when it's some other panel in the future that maybe hasn't, they can say, oh, well, the ordinary rule is you're going to have to be readmitted in the other jurisdiction first. And so now we know what standard and the future respondents will know what standards they need to meet in order to overcome that. So so it's not a distinction between a presumption and case by case. When an attorney has an argument, it's always going to be case by case. But what we're asking is for the court to provide guidance to future respondents and to future divisions of the court that have to consider these questions.
Well, but a moment ago, as you were laying out how you view the framework, at each stage of this reciprocal discipline and then future reinstatement, the burden is already on the attorney to show by clear and convincing evidence. The presumption seems to then add another burden on top of that. Why is that necessary?
So I don't think it's really so much. It's certainly consistent with how the rest of this process goes. I mean, the reason for the presumption is basically the reasons we have reciprocal discipline and discipline in the first place, which is to protect the public and the practice of law, the courts in District of Columbia. Ordinarily, in most
that's already weaved into the reciprocal discipline and to the reinstatement process.
Yes, but what I'm suggesting is, as Judge McLeese mentioned earlier, is basically doing the same thing on the back end as we did on the front end. Ordinarily, the original jurisdiction is going to have access to more information. They're going to have the witnesses. And one important thing that we mentioned in our brief, but I haven't said today, is often there are other allegations of misconduct, other complaints against that attorney. In DC, when this happens and somebody's disbarred, we dismiss those, and nobody ever hears about them. And in fact, we can't tell anyone about them because they're confidential. So if you have someone who engaged in misappropriation, there could be 5 more misappropriation complaints behind that. And when the person comes back for readmission, it is certainly relevant that the person didn't just have one mistake, however they're going to characterize it, I had a lapse in judgment. What was really happening was a pattern of stealing clients' money, and that person should be less likely to be readmitted than the person who can credibly say.
How would you get at that if other cases like that existed? If in DC, our practice is to dismiss other cases.
So in DC, when they come back, we can bring those matters up on as part of in opposition to an application for readmission.
Yeah, I think that seems to bolster my theory that DC doesn't need you don't need a presumption in order to do that.
Well,
You
but
would
we
already do
do,
that.
because if the person were, if the person is disbarred in DC, we have the complaints and they come to seek readmission in DC. If they were disbarred by another jurisdiction like Virginia, Virginia might have those same backup complaints. They can't tell us about them. And if we have to adjudicate, if this court has to adjudicate the readmission, it will never learn about that. We just have less information in order to make a responsible decision.
Could you require, or at least inquire and then respond to the inquiry of people seeking reinstatement who are disciplined elsewhere, whether they're aware of other complaints that were dismissed in virtue of the earlier discipline? Is it really completely inaccessible to inquiry?
So they are confidential and we would not reveal that information.
No. My question is, if, let's say someone was disciplined in a foreign jurisdiction and there was not a requirement of being reinstated there, and that person sought reinstatement here, and your point is, well, there might be things known in the foreign jurisdiction that are confidential there that you wouldn't be able to find out. And I was just trying to figure out whether that's really so impenetrable a black box, or whether instead it could be part of that's a point you could raise and a question that you could direct at the person seeking reinstatement and take into account how they answer it. It wasn't entirely clear to me it's an impenetrable black box. My question was along those lines.
Well, you certainly could ask the person about it. I don't think they would be prohibited from answering, but we deal with a lot of people.
If they were unwilling to answer, one could argue as Office of Disciplinary Counsel that should be taken into account, I would think.
Well, I mean, if they're going ahead and willing to admit that, yes, there were 10 other complaints against me.
Oh, no, if they said I'm not answering that, if they said I'm not inclined to answer that question, for example, you compel them to answer, but it might be a relevant consideration that they're unwilling to do so.
But they also might lie.
Understood.
Yeah.
Can I ask you 2 things? First, you said you perceived 2 questions the chief was asking you, and I just wanted to make sure. I know you expressly addressed one. Was there another one that you haven't gotten around to? And
sure.
I wanted to
I think
give you a chance to do that.
Yeah, the second half of that question, as I understood it, was the application of our position to Ms. King's case. And there, the question is, she says, well, I've practiced in DC a long time, and and so DC knows enough about me to evaluate my fitness when I seek readmission. I think it's important, however, we didn't prosecute these cases. And if you look at the underlying conduct, it involves not just multiple instances of what would be, I think, at a minimum, negligent misappropriation, and if not for one finding of the Maryland Appellate Court, likely reckless misappropriation. We don't really know what led the court to add that extra. There wasn't dishonesty, and we're not really in a good position to evaluate this. There's a record. I don't think the record is completely clear. It also includes findings that she obstructed engaged in a bad faith obstruction of the disciplinary investigation. And there are some details about it, but there's only so much. And then finally, there is the practical problem, which has already been discussed, which is we haven't asked for a monitor. We haven't asked for probation. I think it would be an odd situation for DC to try to enforce a probationary period or have a monitor to do the things that Maryland thought were required. If, as it stands, if you were allowed to seek readmission here, then with skipping Maryland, you would basically avoid those conditions on her suspension.
Well,
in
Why,
Maryland.
why is that? If I would think, I mean, I guess you could try to apply for assuming there was no requirement of like a prerequisite of reinstatement in the original jurisdiction that imposed discipline. And if you were still, your period of suspension had run, but you had not yet been reinstated there, and there were, it might be true that you didn't actually do during your period of reinstatement, during your period of probation, what you should have done, and maybe nobody knew it, and you could try to apply and try to run an end run around, and then the issue is just, again, whether that would succeed or not would depend on the ability of ODC, the Office of Disciplinary Counsel, to investigate and determine what the real situation was. So again, I understand the practical problems. I'm not sure they're insuperable. They're not. I'm not minimizing them. I'm just saying I don't know that they're
Sure, I'm not saying it's impossible either.
Right.
But
I want to go back. I just want to make, because I was surprised by an answer you gave, and I just want to make sure I understand it about how you think Rule 11, Section 3B operates and relates to the exceptions to reciprocal discipline. So let me ask you, here's a hypothetical. Imagine that a person is disciplined in a foreign jurisdiction with a 2-year suspension, but no reinstatement requirement. So it's just 2 years pass and you're able to be reinstated. And imagine that the issue is what discipline should be imposed on that person in DC in a reciprocal matter. And the answer focused on what functionally identical discipline would be under Rule 11, Section 11, would be, 2-year suspension, no need to show fitness. Is it your view that under Rule 3B, the board, the board could recommend, or if the board got involved, but disciplinary authorities could request and the court appropriately could impose a reinstatement requirement in DC, not by meeting any exception in Rule 11, Section 11, but instead by just saying that's a reasonable condition that's being imposed under Rule 11, Section 3B. Is that your position?
so I think so I'm not sure what I can imagine cases where we would request something like that. It would usually be where it fell within, like if I'm trying to think of an example where we might do it, I would say, well, suppose they ordered 2 years. They said, for intentional.
That all sounds like something sounding in the exceptions.
Right, exactly. Which
So
is why
the question I'm asking you is assuming that it doesn't fall within any exceptions, or that's just not the way it's conceptualized. The board or the disciplinary counsel is saying, I don't want to worry about whether I can meet any of the exceptions. I just think it's reasonable to impose reinstatement, and there's
Right.
authority under Section 11, Rule 11, Section 3B to impose any reasonable condition. So it's not an exception question. It's just a reasonableness question of reinstatement.
So I
That's
think
your
the
analytic
difference
position.
here is when I say that I think Section 3 would authorize a reasonable condition, I think when that is combined with Section 11, we're talking about sort of reasonable things that that are the result of.
Reinstatement could quite be, reinstatement sometimes is quite reasonable. So I'm not sure why it would be unreasonable.
So, yes, I guess that you could require the reinstatement in the original jurisdiction if for some reason there were a good reason for that.
So, and it's all, you don't have to fit with any exceptions. You just have to persuade the court that it would be reasonable to do so, notwithstanding that none of the exceptions apply.
I'm having a hard time conceptualizing when we might or why we might ask for it in a reason that doesn't coincide. But let me just sort of try and pinpoint the circumstances that I'm talking about. There's sort of this metaphysical question of what does it mean to be identical, which we talked about earlier. The identical jurisdiction, identical would mean, you know, if you are admitted in Maryland and suspended in Maryland, then you can no longer practice in Maryland. Obviously, that's not what is intended. It's in something similar. And if there is a suspension that is on terms like indefinite, well, we figure out what that means in the District of Columbia and we align it with our law. So when I talk about how the Section 3 gives the authority to do something different that is not identical, it's that sort of ambiguous interstitial space that I'm talking about. I don't think that.
Are you right? I just have never, I'm not familiar with this line of thinking, and I'm just curious, are you aware of cases in which in a reciprocal discipline case, discipline that was understood to be different, not functionally equivalent to, not functionally equivalent to the discipline in the original jurisdiction, was imposed relying on authority under Rule 11, Section 3B, in a case where there was no, or generally, or
So I mean, I think a good case to look at would be In re Baker that I mentioned earlier. There, the court sort of went through the different approaches to reciprocal discipline and readmission under under a couple of different scenarios, and one being when, you know, what do we do when the for example, the original jurisdiction imposes an indefinite suspension with no time for reinstate, no minimum period for reinstatement. And the court said, well, that's mostly like a disbarment. So we say you're you know, suspended and you can reapply after 5 years, which is the equivalent of what would happen if they were disbarred. And likewise, as I mentioned earlier, in cases where the court has, where the originating court has summarily reinstated someone who is disbarred or suspended with fitness without a hearing because there was no objection, the court has said, well, when that happens, we want to make sure that you are, you know, we won't consider it here without, I may be mixing up what the court said, but you know, in some circumstances, depending on what the originating court would do, we will require reinstatement there before you seek reinstatement here. And you might say those are applications of sort of not exactly identical, and how could you, you know, what would be the authority? And I think the answer is, and I admit this is not something that was in our brief or as mentioned before, but you know, one of my colleagues anticipated this question, and we looked it up and figured out, well, you know, Section 3 sort of appears to authorize it. So
I had understood those cases in Ray Baker, as you're describing it, as really more about the sometimes tricky question of what functionally equivalent means, as opposed to some separate authority that you can impose what's understood to not be functionally equivalent, but different.
right.
And not an exception under 3B. I thought that was those are kind of different analytical topics, but I
think if you go through them sort of with a fine-tooth comb, you'll find some of the same difficulties that we're talking about today, where it's not clear whether, you know, what it exactly means. And essentially what we're asking for is to, you could also say is part of making it functionally equivalent in that it is respecting the order of the original court, and it is you know, giving the due deference and reliance that we place on the front end at the back end, and that would be another way to, I think, justify it. You wouldn't necessarily need to use Section 3.
Counsel, let me pull you back on just an more abstract question. With all of the debate we've had and all the complexities of this, it just continues to strike me more and more. Why wouldn't something like the interpretation seems like it's doing a lot of legwork. Why would something like a rule change where we can get wider notice and comment not be the better route to clarify something that seems like it's potentially fundamentally changing the way we've operated and the way the rules are with regard to the presumption?
So I actually don't think it's that much of a change. If you, and certainly, you know, rule change would be welcome, but you know, that takes time. the requirements for readmission are already largely set out in statute. There is a general statement in the rules, but the Roundtree factors are very specific, and those are set out in case law, and everybody knows that that's what you need to follow when you are seeking readmission. So I don't think this is actually moving the ball that much. Like I say, it's not that this is a per se rule that we will never never allow readmission without readmission in the original jurisdiction. It is just sort of explaining to future respondents and to disciplinary counsel, and for the benefit of future divisions of this court, how do we decide this question when there's a dispute about it? And I take it that's why we're here. We have two cases in which there's a dispute, and so we'll decide, what are the guidelines to use.
I wanted to focus you for a minute on the two specific cases that bring us here. And it seems to me that the exceptions could eat up the rule if we impose a rule with or presumption. And it seems like in different ways, the two cases before us might illustrate that. Arguably, as I understand Mr. Yoder's argument, he doesn't think there should be a presumption, but if there were a presumption, he would fall within an exception in that he doesn't intend to ever practice in Virginia again. Ms. King, I hear arguing another type of exception, maybe two other types. One, the presumption really wouldn't apply to her because you already have a fulsome record of what happened in Maryland to know how that would factor into the exercise of the Roundtree factors. And further, another potential exception is that she already had and has and would like to continue having a practice here in DC. So those are three exceptions potentially illustrated here for reasons that folks would want to get around or be excluded from any presumption if it did exist, which lead me to wonder why we would need it. I mean, wouldn't we be better off continuing with our case-by-case analysis where we would be considering all those factors that would then become exceptions if a presumption was implemented?
Sure. So I wouldn't call them exceptions. I would call them, considerations. And if you want, we can talk about how they should apply to these specific respondents. But as to why this would be helpful, I think the answer to that is there are far more reciprocal cases in this jurisdiction than there are original cases. We have the attorneys who are licensed in the District of Columbia are often licensed in many other jurisdictions. And so a second reason for reciprocal discipline in the first place is a matter of efficiency. We're here arguing a case, with multiple respondents. I would suggest most reciprocal cases do not wind up with an argument, and it would be not helpful to this court's docket if they did. So to the extent this court can provide some guidance as to when it would be appropriate or not, and I agree that the matters that they've raised are legitimate subjects of inquiry, right? So if the court says, as you suggested earlier, that an attorney just doesn't want to go back to the place that is disbarred him in the first instance, I agree with you. I don't think that is enough to overcome what would be the general idea that we're not starting from scratch. There are good reasons that an attorney wouldn't want to go back. They've got his number, right? So I don't think that is enough, and it would be helpful if the court said just the desire, self-professed desire to not return to the jurisdiction really doesn't get you past this condition. With regard to Ms. King, I think, and actually with both respondents, the underlying misconduct here in both cases involves involves failure to cooperate with the disciplinary council. And they both involve financial misconduct. Both of these respondents took money that they advance fees that they received from clients and deposited directly into their operating account, likely spent it, and then some of it was refunded. But there are questions about that conduct. And so there are questions to which the original jurisdiction has better information to discuss than we do. So, it would be helpful.
How does Maryland have better information than we do with Ms. King's case? Because don't we have everything in the record from the Maryland proceeding?
I don't think we do. What we don't have are the financial records and the expertise of the person who went through. And I mean, this court in an order within the last year, asked what is the sanction when someone's record keeping hides more serious financial misconduct like misappropriation or commingling. And that's the sort of information that the authority, which was investigated and was really looking into all of the evidence, is prepared to answer. Whereas
I'm sorry. In Ms. King's case, if she followed the proposed change and sought reinstatement in Maryland, got reinstated in Maryland, and then came to seek reinstatement here, you still wouldn't have the bank records or the expert witness.
That's true, but what we would have is I happen to think, and if she is pursuing readmission in Maryland and is successful, I think she probably will have a pretty strong petition for reinstatement here. It's particularly if she is under probation and being monitored by a person in Maryland. I can't see why we would ask for a second monitor or a second period of probation on top of that. But what we would have in the situation you described is we would have the benefit of Maryland's evaluation that was where they had before it the disciplinary authority in Maryland, which could answer those questions if they were there. This jurisdiction is an original matter. Disciplinary counsel, we just don't have access to it. So if there's an argument to be made, we won't be able to make it. And the only person that suffers, I just want to step back for a second. These cases involve disbarment and suspension with fitness. There's a reason that attorneys have the burden to prove their fitness. The default, there's no right to be reinstated. And it's not just even a preponderance of evidence. They need to show by clear and convincing evidence. They need to prove that they are fit, that they have addressed the misconduct and fixed it, and they have good character, and that they're qualified to practice law. They don't there's no benefit of the doubt in those cases. These are serious cases where in fitness cases, the court has decided, like a firm belief, a strong belief, that if they're permitted to come back, they are not likely to follow the rules of professional conduct. So, some of these things are difficult for them. I agree, but that's the way the system is set up, and it's set up that way to protect the courts, to protect the public, and to protect the practice of law in DC. As this court has, said many times in Section 2, the license to practice law here, it isn't just, a piece of paper. It is this court's statement that attorney right there, we say they are qualified. They are responsible enough to act as an officer of the court. And so, it should be hard once you've already convinced the court, or once disciplinary counsel has convinced the court that you should be disbarred or you should be suspended and have to prove yourself before you're allowed to come back. It's not going to be easy for them, and it shouldn't be.
Anything else? Thank you, Mr. Metzler.
Thank you.
All right, Mr. Yoder, we reserve 2 minutes of rebuttal I apologize. Yes, I'm sorry. Moved too quickly there. Thank you. Well, no, we're not moving quickly at all today.
You have the heels on, sorry. Good morning. Aisha, may it please the court, Aisha Cassis on behalf of the board. I think the piece that the board adds here is just, in our brief, we we are proposing that the standard applied to the exception be unique and compelling circumstances. So that is the piece that we, based on the court's delay case law, that is the piece that the court, that the board offers.
So when you say does that add more or does it lessen the presumption that the disciplinary council is asking for?
I think it sharpens it and gives clarity on, what that standard is, and ensures consistency across cases. So I think it makes clear that it's not any argument that a respondent may have about why they should not be required to be reinstated in the original jurisdiction, but something that is unique to their particular case that makes it uniquely difficult for them to proceed with the process of, as Judge McLeese was saying, now I have, I'm terrible at algebra, but I have, 1 times whatever to do. So I am uniquely challenged here.
Can I ask you the question that I asked disciplinary counsel, which is, I know this isn't your position, but assume for a moment that the court was going to decide that functionally equivalent discipline would be either, but not both of, reinstatement in this jurisdiction or reinstatement in the originally disciplining jurisdiction. So assuming you could pick only one horse as what would be functionally equivalent and therefore would be applicable unless an exception could be proven or unless perhaps it was reasonable under Rule 3B, which horse would you pick? Does the board have a position on which of those two things would be the better conclusion? Only one would be functionally equivalent discipline?
I'll speak on, I have not conferred with the board on this, and so I'll just speak on give you my thoughts on that. As a general principle, I would think that the preference would be that they be required to, well, that it be interpreted to mean to get back into your originally disciplining jurisdiction first. I mean, I do think, I want to think about that a little bit more because I think we had a reciprocal discipline case about 2 years ago in Gonzalez where Judge Thompson walked through the analysis of why the court has interpreted the requirement with suspension with fitness in the other jurisdiction to mean suspension with fitness here. So I would want to go back and look at that again, but just standing on my feet here, I would think it would be the jurisdiction that has the most information about the misconduct would be where you should get back into first. And then, to the point that I think Judge Howard raised, I mean, that, there could be a discussion about, the Rules Committee could have about a rule change to have functionally reciprocal reinstatement to go along with that analysis. But again, that's just.
Thank you.
So under the board's interpretation, you said arguments could be made by the respondent to rebut the presumption, but they would need to be unique and compelling. So how would you map that structure onto the 2 cases that are before us today?
Well, I think that in the case of, and we did not, I don't think we addressed it in any detail in our brief, but just again, standing here, I think that Ms. King's case could theoretically be a good example for where there are unique and compelling circumstances, because I will take it as true that there is not the information imbalance in that case, that all of the information is available. Different than, and that there are no issues, for example, of misconduct that is confidential, alleged misconduct that's confidential, that disciplinary counsel can't effectively investigate in order to present a full record to the court in terms of why this respondent should or shouldn't be readmitted to the bar. I think that's different. I would see it differently in Mr. Yoder's case because I do think that information imbalance, there are issues there that present the information imbalance issue, and also and the record here of the practice. I would think that'd be a weighty factor that the court can consider. That maybe I don't know that that's the case in Mr. Yoder's matter.
Thank you. And I guess my last question would be, why isn't a case-by-case analysis that we've been utilizing up to this point sufficient to get at unique and compelling circumstances?
I mean, I think in the board's view, it would just give some, again, notice and predictability and consistency across cases. And for the court, consistency across the cases that come before you, of how high a burden the respondent should, the petitioner in that case should have to bear before stepping aside from that presumption.
Thank you.
Thank you.
All right, Mr. Yoder, you reserve 2 minutes for rebuttal. We can't hear you. I think you're on mute.
My apologies about that. I just briefly wanted to just sort of pull back from the very deep weeds that, a lot of the questions got into, and just from a higher level, just re-emphasize the fact that what this is doing, if there was a presumption, would be taking a rule that is permissive on its own, which is it's within the court's discretion to impose the discipline to begin with. There's nothing that's, obligatory, to where that would jump on the textual language of the statute to imposing essentially 2 presumptions under a discretionary standard, which again, I'm not saying that there's an issue with that, but all that I'm requesting is that there be, instead of it being you have to seek reinstatement, this presumption turns into you now have to prove your ability to then seek reinstatement on top of prove your fitness once you do get the ability to seek the reinstatement. So to me, that's unduly prohibitive. And in terms of the discovery of the evidence or information, I fully agree with bar counsel's arguments, but I also believe that if an applicant for readmission isn't willing to waive the confidentiality or cooperate, that should be pretty indicative on their face about their fitness to return to the practice of law. If they wouldn't be willing to, sign something waiving confidentiality to give the bar access to file a subpoena ducis tecum to obtain the documents or file from the other jurisdiction, I don't see, to me, that would weigh, against their character. So in my circumstance, I'd be more than willing to sign that, to give them any documents that they needed in the other jurisdiction. So that overcomes the issue there in terms of information. And I just think that the public being protected is really what the whole purpose of the reinstatement process is. And requiring someone to seek reinstatement in another jurisdiction in order to overcome a presumption against them being able to seek reinstatement here doesn't further the interest of protecting the public.
Thank you. Thank you, Mr. Yoder. Ms. King?
Yeah. I do believe this came down to whether or not bar council felt that it would be more efficient. And I think that efficiency isn't really the biggest question when it comes to ensuring the safety and the well-being of the community. In this particular case, in my case, all the information is available in the Maryland file. There were 3 main issues. That I charged a $2,500 fee. All my bank statements were attached as exhibits. They saw that I refunded that all $2,500 back. So I know counsel said that he wasn't sure. That's efficiency, meaning they would have to take the time to read it, but it's all there. I missed the statute of limitations deadline. That's all in the records. I missed it by a day. Nevertheless, I missed it. That was wrong. It's in the record. And obstruction, word obstruction is bad. It sounds bad, but the facts are in the record. Bar counsel said to respond in 2 weeks. I may have responded in a month. I won't do that again. I'm not playing with bar counsel. If they say 2 weeks, I'll get it back in 2 weeks. And I'm sure everyone else who is hearing me should respond to bar counsel. So I just believe strongly that a case-by-case rule is appropriate because not every case is the same. And there is still the burden on the attorney to make the petition to show that they are a fit person and they meet all the Roundtree requirements. And while it may be a little bit more work on bar counsel and they're already very busy, but I do believe it is appropriate to look at these cases individually as opposed to collectively. Thank you very much.
All right, thank you. All right, we thank all parties for your briefs and arguments today, and we'll take the matter under advisement. Our third and final case this morning is MARQUET BOATWRIGHT versus United States.
The court's permission, good morning. David Ryder on behalf of Mr. Marquette BOATWRIGHT, and we request that his conviction be reversed because he has a Fourth Amendment standing to object to this warrantless search. And if I'd like to reserve about 2 minutes for rebuttal. Based on cases such as Minnesota versus Olson and this court's own holding in Profit versus United States, it is Mr. Boatwright's position that he had Fourth Amendment standing here. He had very strong privacy interests in this property. He had been on this property for over a week. He had been in the property.
Well, can I interrupt you?
Sure.
For starters, it wasn't his property.
Correct.
It was his, I guess, girlfriend's property. That's who held the lease. And he was, to the extent he was there for a week, it was because she, at least for some part of that time, may have invited him. But there is in the record information that seems to strongly indicate that there came a point in time where she made clear that she no longer wanted him on the premises, and therefore he was no longer invited and did not have a privacy interest. That sort of, where am I wrong on that?
Certainly, Your Honor. The child's mother did say in her 911 call, I've been trying to get him out for a week. That's a landlord-tenant issue in terms of the landlord-tenant.
How is that a landlord-tenant issue?
Well, in
He
other
wasn't
words, an
paying rent.
overstaying guest, there are plenty of those cases. But what's important here on the record is that the United States never called the mother. The mother never testified.
Hearsay is admissible at suppression hearings, so why does it matter? I mean, it's relevant, but why is it fatal
Sure.
to the trial court's finding that there was hearsay evidence on this topic rather than live testimony?
Well, certainly there was no evidence, and certainly in the child's mother's statement on the 911 call, when and if she ever told Mr. Boatwright to leave the property. That's what makes this very unique.
Well, I guess it's a question of what officers reasonably ultimately what the trial court found, I guess, for purposes of standing, not what the officers inferred. But I would think that a fact finder could reasonably infer from what was on the 911 call, which is I've been trying, paraphrasing. So if my paraphrase runs afoul of anything, please step in. But I've been trying to get him out for a week. We got into an altercation, and he put me out, and my child is in there, and I'm afraid he's going to leave with my child, and I don't want that to happen.
Mhm.
I would think a reasonable fact finder could find from that if you're trying to get someone out, the way you do that, at least one of the natural way you would do that is to inform them of that. If you're not doing a good job of trying if you don't let them know that that's what your objective is. So couldn't the trial court, this is ultimately to a degree a factual finding, couldn't the trial court infer reasonably from that 911 call that she had communicated her interest in having him out to him?
Well, not in this case, for the specific reason, again, there was no statement or even concrete proof when and if she told him. But the important thing here is that Mr. Boatwright, again, we don't know what the dispute was. And the trial court's finding was that Mr. Boatwright was not on the lease. And she also cited, the government brought in the lease. That decision is erroneous because Minnesota versus Olson says property rights are not determinative.
But it's certainly relevant. It's not, are you saying it's factually erroneous, or you're just saying it wasn't, that finding by itself didn't defeat your client's standing?
That
If
is correct.
That's certainly true.
That is correct.
That's certainly true.
Right.
I completely agree with you on that. But the issue, I guess, for me is if you take that as true, so that would have been another way your client could have established standing if it were true, but it isn't. So his theory has to rest on the idea that he had been an invited guest overnight or longer. And the trial court's view about that was that essentially, again, paraphrasing, so feel free to step in, but was essentially he may have been invited at some point, but ultimately he was disinvited and wouldn't leave. And do you agree that, assume for a moment that the record adequately supports an inference by the trial court that your client had been informed by Ms. Boatwright that she didn't want him there? Would you agree that if that is a reasonable factual inference, if that the record supports that inference, that it follows that your client lacks standing?
Well, I can't because that did not occur and it's not certain here. I
I
understand.
understand. I'm
it's
just asking,
concerned.
assume a different record. Imagine that Ms. Boatwright had come in and said, I asked him to leave and he wouldn't. Would you agree that if if those were the facts, that your client lacks standing?
And when she communicated it, but it didn't occur in this case.
I understand that. I'm
Right,
just
I
asking a
understand.
legal question. Imagine a hypothetical case
I
where,
understand.
let's say I invite you to, you invite me to your house
Mhm.
and I stay for a week. But on day 5, you say, I'm sick of you, get out. And I say, sorry, I really like it here, I'm staying. Would you agree that if those are the facts, I lack standing? If the police enter at some time after that conversation?
If you didn't have your child there or had a strong familial tie to the
Well, even
property.
if I mean, I'll add in, I'm with you. I
Right, that's
assume
why-
that my child and I were staying and you were trying to get us to leave.
Yeah, we don't know that. That's
Understand.
the
But-
difficulty
So you think
we're
that
having.
it might be relevant to your client's standing that his biological child was present in the place and that he might have standing to stay there even if he had no property interest because he was not on the lease, and even if the person who did have a property interest told him to leave, you think he
Well,
might still have standing?
I'm sorry, I didn't mean to.
No, that's fine.
No. But in this case, again, there was no communication. Something was going on.
I understand your factual point. I'm just trying to make,
Right.
I understand, I'm trying to separate that from your view about what the law of standing is. And so it sounds like you think, at least arguably, if um, uh, I I have a child in common with someone else and that person lives elsewhere and has a property interest in that place, and I am originally an invitee, and then the person whose place it is says, you need to leave now, and I refuse, that I might still have standing in virtue of the fact that I had been there a bit and that my biological child is there. You think that might confer Fourth Amendment standing legally, it sounds like.
Again, I apologize. And add in the fact that.
I'm just asking, I'm not trying to add in, I'm just asking you about that.
Right.
That scenario and what you think the law is for
Right.
that scenario. Let's not add in facts. I'm just trying to get your answer.
Yeah,
to that
I
scenario.
would say yes. In this case, it is unique. That's what we're trying to put forth. And also during the testimony, and there was only one witness, Sergeant French, he even admitted, oh, I didn't get the permission of the child's mother to come onto the property. Now, could the police certainly knock on the door and investigate? Sure, but they went beyond this.
Well,
The door.
because she called them in a 911 call
Right.
and said that she thought her son was going to be taken away by the person in there, that they had had a fight, she and the person there, and that she'd been
Certainly.
trying to get him to leave. So the police are not just randomly walking up and knocking on a random apartment. They are called when she dials 911.
Just so I can understand, is the court now moving on to the warrantless entry?
Oh,
or?
but no, I was at the point where you said that um, that she never gave permission
Correct.
for them to to be at the home. And I was saying that doesn't seem to be supported by the facts here based on the 911 call she made to the police to come to help her because her son was in there with this person.
Right. She just said I was put out. She's already out of danger. And again, we don't know what happened inside.
No,
that
she said
house.
more than that. She said they had a fight and he put her out. She'd been trying to get him to leave and that her child was still in there. Child did not want to be in there, and that she believed that he was going to be trying to take her child. So she said all these things.
She did. She did.
So
But I
it's
think-
not, and I'm just reacting to your point,
Sure.
which seemed to imply that the officer just appeared and knocked on this door for no reason.
No. I'm not saying that. I'm just saying that the police barged in. They barreled in. They didn't start any inquiry, talk to anybody. And also what's important here is that when the police arrived, the child was not in distress.
Well, that's after
The
they
poli-
get that, they
Yeah.
discover that after they're inside, right? But I
Correct.
just, I mean, it is true that the officer testified that the officer had not been given consent to enter. And in one way of looking at that, that's right. I mean, there was no express word of that. But if you, the 911, this is again, I guess, about what's inferred about things. But if the 911 call is, I've been put out of my apartment by someone who I'm trying to get to leave, and my child is in there, and I'm afraid for in my child's situation, if that's a rough paraphrase of it. It seems like to me, I mean, whether there was consent in part is a legal question, and you would think that is implied consent. I mean, what is that? What do you think the police are going to do if you make that call? They're going to enter the apartment and try to take care of the situation. Then maybe they'll knock if they just choose to, but I would tend to think I would have thought that one could argue that that's implied consent. That's a request that the police go in and deal with the situation.
Certainly, we're not prepared to say that's the case, only because of the unique circumstances here. The police certainly have a duty to investigate. Do they have a duty as soon as the door is open to barge in and place Mr. Boatwright in handcuffs, which is what they did when the child was not in danger?
But then the situation changes. I mean,
Yeah.
we've been talking about standing, and now we're at the point where the officers knock on the door.
Yes.
Mr. Boatwright answers the door,
Mhm.
and officers and the body cam footage, which is part of the record, seem to show what appeared to be a weapon in his waistband, and then his posture of blading, as it's called, deliberately trying to hide what was in his waistband, then that to me sets in motion a second set of circumstances that may have created the exigency for the officers to go in before they even get to the question of where is the child? Is the child okay?
Well, Your Honor, I think I'll leave it up to the court to view that videotape, but it is very
No, I
nebulous.
just, I think we've viewed that tape.
Right, and it's
We
our
have,
position that there was nothing in plain view. The officer never testified, as this court has mentioned in
The
other.
officer says on the video, it looks like a gun. I mean, if we're talking about the same video.
Right. Again, our position is it was not in plain view, and it was quite nebulous. In prior cases, this court has mentioned in its decision, oh, the officer had all this training and he based his decision because of this and this and this. That was totally absent here. Okay, so that's what makes this quite unique. Now, in terms of the child, well, the mother said, well, I think Mr. Boatwright is taking the child. I point the court to DC Code 16-1022. That's the Parental Kidnapping Act. That was not occurring here. Did Mr. Boatwright violate any custody order? There was no evidence. Was there any evidence that he secreted the child? No, it's right where he lived. Is there any evidence under the Parental Kidnapping Act that he failed to bring the child back from visitation? No, he's in there. And finally, is there any evidence that he left the jurisdiction with the child? There is no evidence.
Can I ask you about a different possible offense?
Of course.
And I know that you don't agree with the factual premise of this question, and we've discussed an aspect of that before. But assume for a moment that the trial court could find as a fact finder, or a reasonable fact finder could find that the lease for this location, your client was not on the lease, and that the leaseholder had asked your client to leave and your client hadn't left. Assume that if those are the facts, would you agree that those facts, which I know you don't think are the facts here, but if those were the facts, would you agree that that would create probable cause to arrest somebody for unlawful entry or refusal to quit?
No, because again, that is such a general thing. You'd have to investigate. Why are you here? How long have you been here? Are you paying the rent or something like this? That happens all the time in landlord-tenant court here. Again, we're looking at, did.
To make clear, again, this is a
Yeah,
probable cause
sure.
question, not a sufficiency of the evidence to convict question. You're saying if I go to a police officer on the street corner and I say, officer, I live in that apartment right there, and there's somebody in there who I told to leave and won't leave. You would say that isn't probable cause for the officer to arrest that person because the officer would have to somehow verify what I'm saying before the officer could act upon it?
Yeah, because how do you know the person is telling the truth?
You often don't when you are an officer
Understand.
arresting on probable cause. There's sort of an assumption that unless you
Right.
have reason to believe otherwise, what a citizen is telling you in person is sufficiently reliable to arrest folks. So you don't know for sure. That's definitely true.
Right. But that, again, if a trespasser, that's a different circumstance, or the person said, hey, look, just for a few minutes, like the court ruled in Profit versus United States, there's no standing when the people have been in there with many people, but for a few minutes. The only people in this apartment were Mr. Boatwright and his child. Would he have a sufficient Fourth Amendment privacy interest that society would deem as reasonable under these unique circumstances, under cases such as Rackus versus Illinois? It's our position that yes. And then when you look at whether the court ruled correctly, because the trial court did have a fallback position saying, well, even if he had a privacy Fourth Amendment interest, this was a warrantless entry exception. It's our position that that did not take place here. A warrantless entry exception would have to be, is that person inside having any sort of emergency or danger? There was no proof of that. The officer said the child did not look in distress. Was the entry tailored to assist that person in danger? That was not the case here. And finally, was the entrance, a warrantless entry by the police, not primarily for the purpose of either arresting someone or searching? That definitely didn't happen here. So that's why we feel comfortable for the court in this case that this suppression judgment must be reversed. If the court has no further questions, I see my time.
Yeah, I have one further
Of
question.
course, of
Just
course.
the trial court in returning its making its ruling said that let me make sure I get it correctly here. Referred to as a little unclear whether it's a finding, I guess, that'd be a possible question for you to address, but refers to the idea that there was a person inside the apartment who was refusing to leave. So if you take the trial court, which you may or may not be accurate, but assume the trial court has made a finding of fact that your client was refusing to leave, do you think that would be a clearly erroneous factual finding if it is one?
Under this circumstances, yes, because there's absolutely no proof. Could the child's mother, the leaseholder?
Well, you say absolutely no proof. I mean, the 911 call is, he's been there for a week and I'm trying to get him out and I'd like your help to get him out and he's put me out. That seems like it may not be adequate proof, but it makes it hard to say there's no proof.
Well, I would once again point to the fact that the trial court really relied primarily on its decision for no standing, that he wasn't on the lease, not what you're bringing up right here, Your Honor. So again, this is a rather unique circumstance here. And that's why we feel comfortable in asserting this argument and asking that the case be reversed.
Great. Thank you,
Thank you.
counsel. And we'll reserve for your 2 minutes of rebuttal.
Morning, may it please the court. Elizabeth Gabriel on behalf of the United States.
Do you have some special guests with you today?
I do, yes. I have two of my children and one of their friends who, two of them are on their mock trial team in their high school. So they wanted to come and see what a real courtroom looked like.
Well, welcome to the DC Court of Appeals.
Thank you. The totality of the circumstances in this case supported the trial court's conclusion that the officers acted reasonably in response to exigent circumstances. And I'd like to start with that because I think that the emergency aid exception here justified the police intrusion in this case. And as a result of that, the court need not reach the standing issue. I'm happy to address that as well if the court has questions, however.
Well, I would have thought that you would have reversed the arguments and started by saying we don't have standing, so do we really need to get to the exigent circumstances? So I would be interested in hearing what your standing arguments are in response to some of what Mr. Reader said.
Sure, and the reason I don't start with it is because, and I understand appellant to be making the argument that the issue of standing only goes to whether the police were justified in actually entering the premises, but that appellant would have standing to object to the search of his person. And so we think that the entry into the home was justified by emergency circumstances, and therefore, and the response that, you know, the police action within the home was part of that, including the stop and seizure of appellant and the seizure of the gun on his waistband. So that was all a response to the emergency circumstances that faced them. But I can definitely start with the standing issue if the court would prefer. We think that there was strong evidence in this case that Mr. Boatwright did not have standing. The 911 call makes very clear that Ms. Stevenson had been trying to get Mr. Boatwright out of her apartment for a week and a half. She says that they fought, and they fought because she was trying to get him out. So I think it's pretty clear that she made it clear to him that she did not want him there. And then, of course, he forces her out of the apartment and doesn't allow her back in. So based on that evidence, I think, you know, there's no way that appellant can establish that he was still an invited guest at the point that the officers arrive. And in fact, in the conversation that takes place after the officers detain him, he admits that he doesn't live there, that it's not his place. And we know from the lease agreement that he's not on the lease, and that it is in fact Ms. Stevenson's apartment. Again, the circumstances here allowed the police to enter because, number one, they knew that Ms. Stevenson and Mr. Boatwright had fought. They knew that he had put her out of her apartment and would not allow her back in, and that he in fact separated her from her child who was in the apartment, that her child didn't want to be in there and was crying, and that he had talked about removing the child and leaving with the child and was making arrangements to do so.
Now she's asked on the 911 call, were there any weapons inside? And she says no. So when the officers knock and enter the apartment, happens pretty quickly. Are you clear that the record supports finding that they saw the gun and then handcuffed him, or that they were moving to handcuff him and saw the gun? What's your interpretation of what the video depicts there?
Well, the testimony at the hearing, and I think this was corroborated by the video, was that when the officers knock on the door and Mr. Boatwright opens it, he immediately turns his body away, puts his arm right at his waistband, and you can see in the video pretty clearly that there is a bulge consistent with what the officer testifies as being pretty recognizable as a weapon. And this is before they enter. This is while they're still at the door. And so based on that, I think, you know, they enter and immediately cuff him, and they tell him this is for your safety and our safety, and then remove the weapon. I think all of that was consistent with a response to the emergency circumstances, and separately as reasonable suspicion that Mr. Boatwright was armed and dangerous.
Going to the first to make sure, you think that as a matter of Fourth Amendment law, if the police are facing like a community caretaking situation where they may need to be like looking out for a child's safety, as you're suggesting here, and they come across someone who they can seize people without having to have reasonable articulable suspicion to believe they're committing a crime, but they can seize people and then frisk them to protect their safety as they deal with the exigent circumstances. They don't need to have like a separate crime that they're worried about. It's just sort of one of the things you can do is if it's reasonable without regard to possible criminal activity. If you're like trying to take care of a child and there's someone there who you think, wow, there's a bulge there, I'm a little nervous about that person. It's part of what the community caretaking doctrine allows is to seize that person and frisk that person.
Sure. And I would make the distinction that this is, again, this is what the Supreme Court has specifically noted as an emergency aid exception as apart from community caretaking. But I don't mean to quibble with that.
No,
But
it's a fair quibble.
But yes, if the potential presence of the weapon is part of what makes the circumstances urgent and potentially dangerous, then absolutely the police can stop and neutralize the danger. That's the whole purpose of allowing them to go in to make these responses to protect the public and anyone who might be endangered inside.
I ask you, so you mentioned a second theory, which is there's reasonable articulable suspicion to believe that he's armed and dangerous. I mean, I guess the dangerous part wraps back around to the circumstance, sort of the same emergency aid type considerations. But on the question, and I get the point about being armed, but there is a question in kind of post-Heller Second Amendment world about kind of our old cases, which were if the police see someone who's not in uniform who has a firearm outside the home, then there's reasonable articulable suspicion to believe their conduct is unlawful because they're unlawfully possessing the weapon. Are you arguing that the police had reasonable articulable suspicion to believe that Mr. Boatwright's possession of the weapon was unlawful and therefore that he was committing some offense like carrying a pistol without a license or unregistered firearm, or are you not arguing that?
No, that's not at all what I'm saying. In this case, they are responding to an emergency. They then see Mr. Boatwright making evasive movements, concealing the weapon on his waistband. They know a child is inside, and in fact, they see ammunition in plain view on a table. And so putting all that together, they reasonably could be concerned for their own safety, the safety of the child, and the safety of anyone else who might have been in that apartment.
Actually, about a third theory, which seemed to me like it might have been more straightforward, but doesn't seem to have been raised in the trial court here, which would have been that the police had probable cause to arrest for unlawful entry, failure to quit. Because if the trial court is finding as a matter of fact that Mr. Boatwright has been asked to leave by the leaseholder and isn't leaving, that would seem to be an offense in and of itself. But am I right that theory was not presented to the trial court, was not ruled on by the trial court, and hasn't been raised in this court?
Well, the trial court did consider that that Mr. Boatwright was potentially committing an unlawful entry. The court said that at the same time that it said, and I can draw the court's attention to the record, where this is on page 11 of the August 22nd transcript. And the court says, right, that they had somebody on its face who was potentially committing a crime of either trespass, which he then says is what we refer to as unlawful entry. So the court did consider that. Of course, it wasn't
not briefed in this court. Is that right?
No, it wasn't briefed in the court. And but we do think that that is an alternative basis, of course, for the stop of Mr. Boatwright and the search of his person. But in this case, we think that the evidence so strongly showed an emergency here to which they reasonably responded. And part of that response was seizing the weapon, which potentially posed a danger to them and the child. Okay, if there are no further questions, we would ask this court to affirm.
Thank you. Mr. Reader?
One, I would like to point out to the court that Mr. Boatwright was not charged with trespassing. And in terms of an emergency exception, the United States singularly cites the Olson versus United States. That was a case where a baby was stolen from a NICU. And when the police arrived at that presence, the suspect had absolutely no plausible reason why that baby was inside. The police knew that this was the child's father. The police show up. There is no sign of distress with the child. So we would take issue. That's what makes this a different situation than Olson, which the government cites.
All right, thank you.
Thank you, Your Honor.
All right, we'd like to thank both counsel for your briefs and arguments today, and we'll take the matter under advisement. Thank you.
It is now adjourned.